live from the drama-free true crime destination. It's your Wednesday check-in with truth, talk, and the stories that won't let go. This is the Mid-Week Byte. And a good Wednesday evening to everyone across this great country. Welcome to the Midweek Byte edition of Bethea'S Byte Reloaded. I'm Ernest Bethea, the Last Outlaw. So good to have you all joining me. I've got a loaded lineup this week. So if you haven't gotten your dinner yet, go ahead, take care of that little bit of business. Get your eats, get your drinks, because right now, it's time for my opening statement on this Wednesday. And let's just say while everybody else is in that mode of bringing the drama, bringing the thunder, I'm in Joe Friday mode. I'm here to bring you all just the facts. While others may bring the thunder, I come in the spirit of Joe Friday. Just the facts. Not to flatten the moment, but to focus it. Because in a world that spins fast and shouts loud, clarity is a kind of mercy. So let's begin with what's real. Not what's trending, not what's tempting, but what's true. The facts may not stir applause, but they steady the soul. And sometimes the quiet voice of truth is the loudest call to action. All right, that's my opening statement. Hit me up in my email, kingofhearts316_09 at outlook.com, and let me know if you're feeling what I'm saying. Right now, let's get down to business. We're gonna start off in Texas. We're gonna start right in the courtroom where we have a verdict where a Texas teen is convicted of murdering his girlfriend's grandmother. So I'm not going to waste any time. Let's go right then. The verdict is in.
Find the defendant, Uriah Lee Urick Jr., guilty of the felony offense of capital murder as charged in the indictment, signed by the foreperson of the jury.
Mr. Agnew, would you like to have the jury poll?
No.
All right, you may be seated. So, ladies and gentlemen, at this time, your service is complete. I'm going to ask you to walk back with Deputy Flynn, and I'll visit you in a minute.
All right, thank you.
That was a very short jury verdict. You just heard it, guilty of capital murder. And I want to point out that when asked, do you want to poll the jury, the defense attorney said no. So that's it. The jury's being excused. There is Uriah Urick, guilty of capital murder. Let's bring back in trial attorney Tamika Rabowski. Tamika, your thoughts this is a child that, as the viewers recall, we've been bringing this trial, an 18-year-old, and he and his girlfriend, Tara King, both charged with murdering the grandmother. He's now been found guilty of that. It's the grandmother of Tara King, his girlfriend, their co-defendants. She hasn't yet gone to trial. He was the first one to go to trial. Guilty, your thoughts?
Well, at this point, all that's left to do is to go ahead and move forward with sentencing. And with a capital murder charge, they're going to be digging into, and his youth will be a big that'll be a big point of pointing out mitigating factors to try to get to try to spare him in terms of punishment, because at this point that's all that you can do. Like you said, they didn't even poll the jury, so they're moving onward towards sentencing at this point.
Yeah, and as soon as we get an update about the sentencing date or sentencing for him, we'll certainly let everyone know. Now, you just saw him leave, so there was law enforcement behind him. I'm assuming they were taking him away, taking him back, now that he's been found guilty of capital murder. And I have to add, in this case, you know, part of the defense was to kind of throw it to, it was Tara King's idea, and that she may have been the mastermind. She's not yet gone to trial, and I do wonder if some of that is going to come out again at sentencing to try to convince the court of mitigating factors to give him a better sentence than he might otherwise.
Uriah Urick, 18 years of age, found guilty of capital murder in the death of his girlfriend's grandmother. Here's all the details in this. A jury found an 18-year-old in Texas guilty on charges that he murdered and robbed his girlfriend's grandmother. 18-year-old Uriah Lee Urick Jr. was convicted of capital murder and credit card abuse for the murder of Tammy King on February 5th, 2025. Investigators testified that King was found shot to death in her home, which appeared to have been ransacked. The victim's purse had been emptied, gun safes were open, and her body was covered with numerous sheets that appeared to have been placed over her post-mortem. King's boyfriend testified that before her death, King had been arguing with her granddaughter, Tara King, about skipping school, as well as her relationship with Urick, whom she found to be too loud. Both Tara and Urick were arrested together in Laredo, Texas on February 9. A third suspect, 36-year-old Travis Hodge, was arrested after investigators say he drove the couple to Laredo to evade law enforcement. When Hodge was arrested, he was in possession of methamphetamine and a gun to be the murder weapon in Tammy's death. Hodge took the stand at Urick's trial and testified that he met the defendant after a drug deal and sold him methamphetamine on multiple occasions. A few days before February 7th, Hodge said that Urick reached out asking for a place to stay with guns. He admitted the weapons he found had been given to him by the defendant. Instagram messages shown to the jury between Hodge, Urick, and Tara in the days before Tammy's death include Urick saying, "Don't want to kill her." Tara says, "I've always hated her." Urick says, "Do I kill her next time if there is a next time?" On the day before the murder, both defendants appeared to be under the influence of drugs and discussed methamphetamine in their messages. Investigators said the messages reveal arguments and emotional manipulation. Detectives who testified said the messages also included references to violence, including stabbing and beating. Hodge pleaded guilty to manufacture or delivery of a controlled substance. He's scheduled to be sentenced on January 16, 2026. He faces 99 years to life in prison. Wow. Tara was found to be competent to stand trial in August. Her trial is scheduled to begin on January 5th, 2026. In the meantime, we're gonna stick with this one to see when will Uriah Lee Urick will be sentenced for his role in Tammy King's murder. But for now, we know that he's convicted of capital murder and credit card fraud. 18 years old, ladies and gentlemen, and just threw his life away. All right, let's see what we have next on the docket this week. Oh, all right. I brought this to you a while back. This is the Cleveland entrepreneur. He is going to receive no jail time after his guilty plea. Okay. A prominent Cleveland restaurant owner, if I can pull this back up, a prominent Cleveland restaurant owner, Bobby George, was sentenced to 5 years of probation after pleading guilty to attempted strangulation on Monday. George will not serve jail time unless he breaks the conditions of his probation, and he is not to have contact with the victims or the victim's family for 5 years, ruled Cuyahoga County Court of Common Pleas Judge Joy Kennedy. George was indicted by information, which means he was charged directly by prosecutors after waiving his right to a grand jury. Jefferson County prosecuting attorney Jane Hanlon spoke after the hearing, saying that she worked closely with the victim and her family to hold George accountable and to protect the young woman from any future harm. We were satisfied with the judge agreeing with this, Hanlon said, adding that the agreement has brought the victim some measure of peace and allows her to move forward. Hanlon previously said that it's not that she didn't think there was enough evidence to move forward with a trial, but a young girl in her 20s wanted at some point to move forward, and this accomplishes several things to protect the public, hold George accountable, and protect privacy rights. I believe that he is a man who abuses women, Hanlon said today, and I believe that it took this young girl to make him accountable and to hold him responsible for what he did. After Monday's sentencing, Hanlon said she did not think George got off easily because he will remain a convicted felon for the rest of his life. George's attorney, Kevin Spellacy, declined to comment. According to police reports and court records, the victim, a woman George was dating, detailed multiple incidents of domestic violence. She said George strangled her while slamming her head against the table, which caused her to bleed from the ears on November 14, 2023. Among other incidents, she said George raped her after she got out of the shower, pointed a gun at her, and demanded that she come back inside a residence she was trying to leave, and tried to kill her by shoving a towel down her throat. George initially faced 9 felony counts related to those accusations. According to the Cleveland Municipal Court records, a warrant was issued for George on the following charges in 2024. 1 count of attempted murder, 1 count of rape, 4 counts of kidnapping, 1 count of felonious assault, and 2 counts of strangulation. George owns Town Hall on West 25th Street and Barley House on West 6th Street in Cleveland, among other restaurants and businesses. When asked after his arraignment how his criminal case is affecting those businesses, he said, "This case doesn't affect my business at all. Doesn't affect me or my business at all." And in a way, if you think about it, he might, as crazy as it may sound, he might be right. Now that he's convicted and only sentenced to 5 years probation, that still may not affect his business at all. But that's 5 years without any contact with the victim or the victim's family, like the sentence says. So he's gonna have to deal with this and somehow. Call him lucky that he's not going to prison for this. Next up, an Ohio mother, if you want to call her that. She pleads guilty in the death of her son, who was found dead and chained to a cot. like I said, an Ohio mother, if you want to call her that, you be the judge. We are going to Cincinnati, Ohio for this one. Days before her murder trial was scheduled to begin, an Ohio woman changed her plea to guilty in the death of her teenage son. Tamara Moore was sentenced to 15 to 20 and a half years after pleading guilty to involuntary manslaughter and endangering children in the death of her son, 16-year-old Jeremiah Moore. A police report reviewed by Court TV revealed that officers were called to the Moore Springfield Township home on February 6, 2024. A report of a teenager unconscious and not breathing. When officers arrived, they found Jeremiah dead in the laundry room, lying on a cot. Investigators told the Inquirer that Jeremiah had been chained to the cot and starved. An autopsy revealed there was no food in the child's stomach or intestines, which led authorities to believe that he had not eaten for some length of time. Prosecutor Jacqueline Stachowak described the conditions, saying the room was 56 degrees and Jeremiah was wearing nothing but a t-shirt and an absolutely disgusting diaper. An officer investigating the case told the Inquirer that the victim had autism and was nonverbal. He entirely relied on adults to take care of him. I've never seen such a case that's this horrific. Springfield Township Police Sergeant Ramey Kale told the outlet. With the suffering that they put him through and with him not being able to verbalize the pain or suffering that he was going through. Tamara was arrested and charged alongside her boyfriend, William Turnage. In August, Turnage pleaded guilty to endangering children and involuntary manslaughter. Prosecutors dropped the charges of murder and failure to report a crime. He was sentenced to 11 to 15 years in prison, according to jail records reviewed by Court TV. Nuts. I thought this one would have drug out as far as a trial goes. And she would have been found guilty of murder. Honestly, this woman, and I'm using that term extremely loosely, ladies and gentlemen, she doesn't deserve the title mother. If you're going to treat a 16-year-old, I don't care if a child is 6 years old. If you're going to do your child like that, that's a title you earn, and she did not earn it, nor does she deserve that title. And she's only going to get 15 to 20 and a half years behind 20. What's that? 20. Let me wait. 15 to 20 and a half years behind bars just for involuntary manslaughter and endangering children. You guys go figure how a monster could do that to a child. You already know how I feel about monsters like them. And in case you guys don't, all you got to do is look back at past editions of Bethea'S Byte Reloaded, where there's a story or some story or other about a child being abused, tortured, or even killed by their mother and or father. Next up, a nanny is accused of killing her grandfather, and she is set to go undergo competency evaluation. Ay, ay, ay. We're going to go to the video in just a minute. I just want to bring a little clarity to this, which is the whole reason I do the midweek bite, just for a little clarity. A woman accused of murdering an elderly grandfather while he was caring for his grandchild has been ordered to undergo a mental evaluation. Samantha Booth is charged with first-degree murder and child abuse after allegedly stabbing 83-year-old David Ong at his daughter's home. At the time, Booth was working at the house as a nanny for Ong's young grandchild. At a brief court hearing on Friday, Booth's attorney confirmed that he had received voluminous discovery from the prosecution and had begun to review the evidence with his client. Based on those records and conversations with his client, Booth's attorney requested that the judge order a competency review and a criminal responsibility review for her to be conducted by a psychologist. The prosecution did not object to the request. The judge ordered the exams to be conducted and ordered the parties to return to court in 60 days. When the attack happened, Ong had gone to his daughter's home to check on her child and Booth, her nanny. When Ong didn't offer any update, the daughter called her brother-in-law. He reported Booth in a manic state, covered in blood, and Ong lying on the floor with severe injuries. Prosecutors say Booth had previously watched the child with no incident. Officers allegedly suspected psychedelic mushrooms and marijuana in her purse. At Friday's hearing, Booth requested her attorneys note some matters into the official record, including her difficulty in communicating outside of the jail. All right. Now that you got all that information, I'm gonna take you right to Court TV for further coverage on this story.
Ms. Booth, can you hear me okay?
Yeah.
Is 25-01-779 It's People versus Samantha Booth. Appearances, please.
Good morning, Your Honor. Shelby Sanborn appearing on behalf of the people.
And good morning, Your Honor. If it may please His Honorable Court, Richard Taylor on behalf of Samantha Booth, who is appearing by way of Zoom video conference from the Oakland County Jail, and no objection to appearing by way of Zoom video conference for today's probable cause conference.
Well, Ms. Booth, your first and last name for the record, please.
Samantha Booth.
This is the date and time set for a probable cause conference. Counsel, how are we proceeding today?
Your Honor, at this time, I will say to the court that I am in receipt of discovery in this matter. It's quite voluminous. So I had an opportunity to briefly go over the discovery with Ms. Booth yesterday, Your Honor, but I also had the opportunity to discuss this matter with the prosecutor. Your Honor, based on my initial evaluation of the discovery and my initial interviews with Ms. Booth, I've had an opportunity to speak with her on 2 different occasions at the Oakland County Jail. And based on my assessment of my conversations with her, some of the records that were provided to me in terms of her mental state at the Oakland County Jail when she initially arrived there, it is my request that Ms. Booth be submitted to the Center for Forensic Psychology for a competency review as well as criminal responsibility review.
And more anything from the people?
Your Honor, I've discussed that with Mr. Taylor, and I think that is appropriate at this time. I would have no objection to the referral.
With that, I think it's appropriate as well. I will say that in the past, we don't always get the responsibility report at this level, although I do think that sometimes it is completed at the district court level. So that remains to be seen, but I'll sign orders for both. I'll ask Ms. Sanborn to prepare those and submit them to the court for my signature. And then why don't we set a review date, 60 days? What are your thoughts?
That's fine, Judge. I believe that's an appropriate time frame, given the assessment needed.
All right. The court will set a review in 60 days. We'll send out notice with regards to that. Ms. Sanborn, if you submit those orders, I'll sign the same today, okay?
Will do, Judge. Thank you.
Yeah, Your Honor, if I may, I indicated to Ms. Booth yesterday that I would at least mention to the court that she has had some difficulties with communicating with individuals outside of the Oakland County Jail by way of the mediums that they have, by way of the tablet as well as telephone. She just wanted the court to be aware of that. I did indicate to Ms. Booth that I did speak with her mother and had a limited conversation with her based on the attorney-client privilege that I have. But her mother did inform me so that Ms. Booth can have this for her edification, that they have set up a video visitation with her tomorrow. That is scheduled for tomorrow. Also, Ms. Booth has asked me to submit a request for the video arraignment that was conducted on her behalf. So I'm in the process of doing that by way of forms to the court so that we can have a copy of the video arraignment so that she can be fully apprised, although I've apprised her, so that she can be fully apprised of what she is actually charged with moving forward. There was some other information that Ms. Booth wanted me to discuss with the court in reference to her defense as related to this matter, but I don't believe that it's appropriate for me to say that in a public forum at this time. I believe that needs to remain between myself and Booth, particularly until we get a competency report at this time. So I just want to make sure I put that on the record because Ms. Booth asked me to put those things on the record for her today.
All right, thank you, Mr. Taylor. Of course, we'll wait for your request with regards to the video arraignment and take a look at that once we receive it. I think we're all set for today, though, unless there's anything else from the people.
Not for me, Judge. Thank you.
Nothing else to defense, Your Honor.
Thank you. Take care.
Thank you.
You too.
Okay, so Samantha Booth is going to undergo a mental health evaluation and will return to court within 60 days. And we're going to find out just how competent she will be to stand trial in the death of her grandfather. That's just a wild case for me just to even try to comment on. So I'm gonna hold off on that until the result of the competency examination. All right, next up, guys, the police have released a video of Jesse Butler's arrest after a controversial plea deal. I know there's got to be a little something about that going on. So let's dig in. Ooh, looks like we're gonna this is coming out of Tulsa, Oklahoma, and the video we're gonna get is coming courtesy of our good friend, my man 50 Grand, Vinny Politan, on an episode of Vinny Politan Investigates. But first, the information. Stillwater, Oklahoma police released body camera footage of the arrest of Jesse Butler for multiple counts of rape-related charges. Scripps News is blurring his face due to him being a minor at the time of his arrest. Butler pleaded no contest to 10 rape-related charges and one charge of violating a protective order. Jesse Butler was given a 78-year sentence that would have been around 10 years in prison if served concurrently. However, a deal made between the prosecution and the defense resulted in no jail time, but counseling instead. I'll talk about that in just a little bit. Butler's father is a former football director at Oklahoma State University, leaving some to believe his connections led to a lighter sentence. Again, I'll talk about that in a little bit. The case garnered national attention at the attention of Oklahoma lawmaker Justin J.J. Humphrey. In late October, Stillwater police issued a statement saying they were investigating calls made to Stillwater public schools about the case. All right. So I'm gonna go to some of this footage courtesy of Vinny Politan Investigates. Then I'm gonna come back and I am going to discuss this. I'm gonna comment on this further. As far as I'm concerned right now, this is just part of the comment, that young man just got this. We'll talk about that on the other side.
Insult to trauma. What message does this send when a violent offender like this faces no real consequences?
Get ready to shake your head for the next hour as we go through this story and try to understand what happened here in Oklahoma. Let's begin by bringing in Court TV field reporter Cody Thomas, who's been on this story. Cody, let's start first because I think we all need a clear understanding and picture of the specific allegations of the type of conduct we're talking about in this case.
Yeah, Vinny, it's kind of egregious when you really go through it. Jesse Butler faced 10 rape-related charges for alleged incidents that happened throughout 2024. Now, he pleaded no contest to them in the spring of 2025, but 2 victims came forward describing brutal sexual assaults, attacks that left them injured, no less. They said Butler forced them into having sexual intercourse and into doing sexual acts, saying they lived in fear, giving in to Butler's sexual demands in order to avoid him hurting them even more. Now, these 2 girls said they each dated Butler for a few months each. One victim described multiple violent sexual assaults. Now, she said one time she told Butler she did not want to have sex with him, but, and we'll quote from the rest of the arrest warrant affidavit now, Butler became angry, came up behind her, put his arm around her neck, and strangled her to unconsciousness. She could not breathe, scratched at his arms and tried to get away, but she could not free herself. The victim woke up on the floor of the living room after losing consciousness. Vinny goes on to say she reported there were red marks across her neck after Butler strangled her. Approximately 15 minutes after strangling her, Butler initiated sexual intercourse with her. Butler had sexual intercourse 3 or 4 times. The victim complied out of fear that he would strangle her again or hurt her. Now, the victim reported Butler wanted to have sexual intercourse every day. She described feeling coerced to comply to avoid being hurt. In addition to sexual intercourse, the victim reported Butler forced her to perform oral sex on him. He forcefully grabbed her head and pushed her down onto his penis. And after that, we feel the story becomes a bit too graphic to read on our show. But it goes on also to say the victim reported Butler digitally penetrated her so aggressively it caused her to bleed. The victim stated, no matter what I told him, it did not change his mind. Now, there are many stories like this. Now, these two victims describe Butler forcing them into many different kinds of sexual acts that they didn't want any part of. And on top of all of that, investigators say they found a video they say shows Butler strangling one of the victims until she's unconscious. They say the timestamp backs up the victim's story. Now, I want to point out, Butler wasn't charged with rape by sexual intercourse. So prosecutors determined that while he allegedly coerced these girls into having sex with him, they ultimately consented. The charges were strangulation related and for kidnapping, sexual battery, and attempted rape and rape by instrumentation, among others. And again, Butler didn't spend any time in prison as a result of a deal between prosecutors and the defense. Butler is now 18, but he was under 18 when these alleged incidents happened. He was given a 78-year sentence that would have resulted in around 10 years in prison if served concurrently, Benny.
And it's corroborated by the video. So one of the stories, that she gives, one of the statements that one of the victims gives is fully corroborated on the video, which tells you about the rest of their statements as well. Now, let's talk about the victims here. Have we heard anything from the victims?
Yeah, Vinny, we have. The arrest warrant affidavit included what looks to be a letter one of the victims wrote to the court. And in it, she says, quote, "I will never forget the night you strangled me unconscious because I said no. That moment changed my life. A medical professional later told me that I was just 30 seconds away from dying. 30 seconds. If you had kept your hands on my neck just a little longer, I wouldn't be standing here today. That wasn't just a scare. It was a near-death experience. You didn't just hurt me. You nearly killed me. And because of that one act of violence, I had to have surgery on my neck. The damage you caused wasn't invisible, and it wasn't temporary. The pain lingered for months, and now the scar is something I'll carry for the rest of my life, a permanent reminder of what you did to me. I will never forget marble slab when you pinned me down, touched my body without permission while I begged you to stop. I screamed no over and over, and you ignored it. I will never forget what it felt like when you pinned me inside your truck and said, you're not going anywhere until I finish. Like I was just something to be used. You didn't just hurt me physically. You took pieces of my safety, my peace, and my sense of who I was. What you did wasn't just violence, it was betrayal, fear, shame, humiliation, and pain layered over and over and over again. He told me that if I ever told anyone what he was doing, he would kill me, he would kill my family. I hope that one day you actually face what you've done, not just get punished, but really face it. Every time you ignored my no, every time you forced yourself on me, every time you laughed while I cried. I hope you understand how much it haunts me. And Vinny, some parents of the victims also wrote letters to the court as well, but Vinny, reading those words right there written by that victim, it's almost like you can just feel the pain and trauma with each word and each line that she wrote in that letter.
And again, the allegation corroborated on video. All right, Cody's going to stick around tonight. Thanks, Cody. That gets us to our first question tonight. And I think this is the most important question. What about the victims? What about these two victims? What about victims in general, future victims? Nothing happened to this young man, nothing of consequence. Here to help answer that question, digital journalist Justin Shepard. Justin's been working to shed light on the story to help protect victims and prevent others from being harmed. And Pascal, the host of the Pascal Show, Justin reached out to Pascal to flag him about this story and has been on it. Justin, I think, the story starts with the victims here. What about the victims? And I feel like for these two young ladies, it's going to be a long, difficult road for them. And then the salt in the wound is is that, oh, look who's out.
Yeah, so I totally agree with you. And I think that for these two that came forward, it shows tremendous courage, and they were hoping to get justice. And what they really had happen to them was originally that 78-year sentence whittled down to 150 hours of community service. And I know that I'm oversimplifying that. But basically, that's what this is about, and what the state of Oklahoma, what Payne County, Oklahoma said to these victims, in my opinion, is that you don't matter. This guy's more important, and what he did to you is of no consequence. And that's really what it's saying to these girls, because they're girls, they're children, right? They're 16 years old when this happens. You can see that he's a big guy. He overpowers them, and there's no justice. This is not justice.
No, Pascal, it's 2025. That, to me, it's 2020. I thought we had turned the corner everywhere, apparently not everywhere, in empowering victims and giving them, say, hey, we're there for you. The system is there for you. Prosecutors are there for you. They will fight for you. They will protect you. And that's not happening here.
You know what's really frustrating about this whole situation is that this is showing proof positive that if you know somebody, if you are connected in some sort of way, you could practically get away with murder. You have these people who are courageous, these women, these young girls that are courageous to step forward and speak out. And now, like what Justin said so beautifully, they're basically being told that, hey, you're just another one because, hey, he's going to go out there and do this again. And I'm not surprised if he's not out there doing it again right now as we speak.
I want to show you an image, Justin. This is from OklahomaWatch.org, and it's Jesse and I guess it's his mother, and they're in the hallway in the courtroom. There's another woman with them. The mother's on the left. He's got like his shades on. Like, what? To me, like a picture can speak volumes. Is there a sense of entitlement, of empowerment over the situation? Like, what's your sense, Justin, of what was going through the mind of this, what do I want to call him? Well, he's convicted, this convicted offender, this convicted, monster. What's your take on his take on what's happening to him?
So the other woman in the photo, as I understand it, is his sister, the one that's on the right. And here's kind of what I think's going on here, and obviously this is my opinion. Jesse Mack Butler is the son of Mack Butler, who is the former director of football operations for OSU, for Oklahoma State University, which is in Stillwater, Oklahoma, where they live. I kind of feel that what this is a situation of, it's a good old boys club. It's about who you know. When you're talking about a town like Stillwater, Oklahoma, that relies on a college like this, you have a person, the mom, my understanding, works for OSU still. The dad used to be a coach, director of football operations. That's going to carry a lot of weight in a town like that. And I feel that there's a lot of entitlement that, hey, and if you watch the body cam footage, he's like, mommy's going to get you out. Mommy's going to get you out of trouble. So there's no accountability from what I see, even from the side of the parents. Like, she knows, what he's being accused of. She knows why he's being arrested. And then allegedly, and this is according to one of the parents of one of the victims, that there was even an incident at that home where he was trying to force himself on one of these girls. She was screaming, struggling, saying no. Mom walks up to the door, knocks on it, and says, hey, is everything okay in there? Jesse responds and says, yeah, everything's fine, and she walks away. This is under her own roof. So I feel like you have a lot of entitlement there with who the Butler family is in Stillwater, Oklahoma.
Yeah, I want to show another picture. This is a picture of one of the victims. Obviously, the face will be blurred out. It's from the New York Post. They say they got it from the victim's family. That's this young girl in the hospital. In the hospital, Pascal. This isn't a case of like, oh, he said, she said, oh, maybe it was, no, maybe. No, there are actual injuries. There's video document. Like, there's no doubt about what happened here. And that's why he pleaded no contest to a certain extent, because he knew the evidence was there. He got a sweet deal, we understand. But at the end of, this is real. This isn't This isn't like, oh, it's in the gray area. It's not even close to the gray area.
Oh, this whole thing is as clear as black and white. There is no reason for him to even be able to be out here breathing in this freedom air, being free right now. I still just don't understand. This whole thing angers me beyond, I can't even put into words. I don't know how this kid, this monster, wearing his shades, thinking that he's Hollywood because he's got connections, because his parents have connections, and of course he's a mama's boy, all right? How he really thinks that he can get away with this kind of stuff and be able to live his life, and as soon as he turns 19, these charges will just get completely wiped clean, and he'll be able to go on with his life. This is not right, and this is not what I call justice at all.
All right, our guests are going to stick around. Coming up next, why did Jesse Butler get this deal?
I had to pause it right here because there is no way I could play that clip from VPI, watch it along with you guys, and not have my say on this. Initially, I said, I even put it in the chat that the boy, referring to Jesse Butler, yeah, and I did refer to him as a boy because he was underage in this. I said he got nothing more than a slap on the wrist. Then I listened to everything that was described on VPI. As far as I'm concerned, he's literally getting away with it. He was underage when he was charged. He was 18 while he was convicted. And I'm hearing now that the moment he turns 19, it's like it never happened. All because mommy promised him she was going to take care of it. Daddy is a former football coach with Oklahoma State University. And a quote my Philadelphia loving TikToker Tiny Tino, are you kidding me? Are you kidding me? Also keep in mind that it's a 78-year sentence. But had they went ahead and did the thing like they were supposed to, that 78 would have been whittled down to just 10. Because it would be have him serve that time concurrently instead of consecutively. But in the end, he's not going to do any kind of time at all. He ain't doing. He's on what? A few hours of community service. He figures. So basically, that's just telling him, that's your dad. Oh, no problem. We're not going to charge you. We're not going to do a thing. Somebody tell me who came up with this deal. And if anybody wants to know how I feel about plea deals, look back at past episodes of Bethea'S Byte Reloaded. You will know exactly how I feel about plea deals. Or let me remind you of this quote from Chief Gillespie from In the Heat of the Night. the quote that says, "We ought to change the Pledge of Allegiance from "and liberty and justice for all" to "and liberty and justice for some, for those who can make a deal." I had to get that out.
TV.
We're done. We're done not saying anything. We're done allowing rapists to walk free.
Public not happy, showing up at the courthouse. Pretty large numbers. I mean, in Stillwater, Oklahoma, you're not in the middle of a major city, and people outraged by what has happened in this case. Let's bring back in Court TV field reporter Cody Thomas. Cody, let's get to the deal now, because everyone's been talking about the deal, and that's what everyone is upset about, obviously. What was the deal here?
Well, Vinny, the agreement kept Jesse Butler out of prison, actually. Now, KJRH, 2 News Oklahoma, reported this. A deal made between the prosecution and defense resulted in no jail time, but counseling instead. Now, Butler's father is a former football director at Oklahoma State University, leaving some to believe his connections led to a lighter sentence. Now, they noted his charges were, quote, downgraded to a youthful offender. Now, all of this upset many people in that area of Oklahoma, and some gathered for a protest. Take a look.
As a, victim myself, I believe that women have the right to, to stand up for themselves and justice to be served, honestly. And none of these girls are getting the justice that they deserve. The plea deal is it's not okay. It's not enough for him. It's not enough. It's a severe trauma that he's inflicted on these women. And for him to get a slap on the wrist, it's not okay.
I feel terrible for those young women. Like, almost losing your life, having a video being recorded of you almost losing your life, and your assaulter being able to just walk with no punishment, a slap on the wrist, and 150 hours of community service. Like, that's just ridiculous. DA and the assistant DA have such a history of either not filing charges against survivors or just allowing the rapists to walk free. I know that because I filed my case here when I was 17, and she wouldn't even file my charges.
Vinny, listening to those women speak, there's clearly a bit of unrest in the community surrounding this case here. I mean, it's not a question of if he did it. We know he did it. There's video. Clearly, people are upset about this in that community.
Yeah, it is a deal of deals for this now 18-year-old. And that brings us to the next question in our investigation. Why did Jesse Butler get this deal? Here to help with our investigation is retired Oklahoma judge and practicing attorney Ken Adair and Oklahoma State Representative Justin Humphrey, who represents the state's 19th district. Representative Humphrey has been very vocal about this story. Thank you both for being here. Ken, if I could begin with you, explain to me and the folks at home not from Oklahoma what this youthful offender statute is, what it means, how it's used, and how it was applied to this case.
We have juvenile justice statutes in Oklahoma where minors are treated in the juvenile justice system. And we have some people that are juveniles who are close to the age of 18 who tend to fall through the cracks and don't get the benefit of the juvenile justice system. So we've created this youthful offender statute, which judges have to follow it if a person is eligible for it, and the presumption that a minor cannot form the requisite intent or the mental state to commit a crime, it's a rebuttable presumption, and if the state can dredge up enough negative past information, prior involvement with the law, they can try him as an adult. It appears to me from the record that he may have been ineligible, or the state could not justify trying him as an adult, which made him eligible for the youthful offender statute. What's really interesting to me is that he pled no contest to these crimes. They also amended the information, which is the charging instrument, and I don't have access to the amended information, but the charges apparently weren't the same as they started. Also, the probable cause affidavit that was read earlier in your segments here were the initial allegations, but there was an investigation that took place. And I'm going to speak generically because these are children, these are teenagers that we're talking about. And Debbie Vincent, the prosecutor, has a very serious reputation as being a hardcore prosecutor, decades of prosecuting sex crimes, prosecuting crimes against women. She is not a pushover. And the district judge that sentenced on this no contest plea, and that's interesting, and I want to talk about that. But Judge Colling noted that he followed the dictates of the youthful offender statute. So he was sentenced to 78 years in prison. There were 10-year sentences, 10-year sentences, other sentences that are being run concurrently, but he was sentenced on no contest pleas. No contest pleas on sex cases is very rare, because if you plead no contest and you go to your sex offender treatment, you go to your counseling and you say, I didn't do anything, you're going to get kicked out and you're going to fail your probation, and off to the hoosegow he goes. So that's curious to me, and what I suspect is, and I don't know, and I think it's wrong to speculate about what did and didn't happen, because we're never going to get the whole story about what happened from these children, these teenagers, about what happened. But for whatever reason, the prosecutor apparently did not think that she could get a conviction, prove beyond a reasonable doubt every element of every crime alleged with these two victims that happened over from the time he was 16 until he was in his 17th year. So I think it's unfortunate because the judge did what he had to do. The prosecutor did, apparently, and this is not a slouch of a prosecutor. There are lazy prosecutors. There are weak prosecutors. Debbie Vincent is not one of those people. She has a reputation of being very tough. And so you heard some anecdotal stories about people that said she wouldn't prosecute her case. I don't know that case, but I do know prosecutors have a duty to not file cases they don't believe they can get a conviction on.
Let me do this.
Because we can't get the full, yes, go ahead, I'm sorry.
I don't want to run out of time. We're always running against the clock here, so I just wanted to get Justin in. And Justin, your thoughts about why this happened the way it happened, and your thoughts about how it's all turned out here.
Well, first of all, we had a grand jury that was canceled just weeks before this. So in this same time period, we're trying to get a grand jury because of these type of cases that are systematic throughout this county. And so, again, it's systemic. I appreciate what your judge there is talking about as far as the how a young man gets adjudicated or not gets adjudicated, held responsible. This guy did heinous crimes. He's 17. It's my understanding, I thought they did adjudicate him and later come back and sentenced him under youthful offender. I'd have to go back and check on that. But the problem is we see a pattern in this county. If you want to go look at, I could give you names right now. We're not going to air those names. But if you want me to start naming names of cases that are just as horrific as this, I can easily name that, including in their own DA's office that they had an ADA that was caught with approximately 150 videos of child pornography in 2022 and is yet to be prosecuted. I would think that'd be high on my list to prosecute. So that's why we were there trying to get a grand jury in that county. We obstructed that. The judge illegally threw that grand jury out. And that's what we're trying to do again, is to expose this very corrupt system that is in Payne County and, again, across the state of Oklahoma. These things are going across the state of Oklahoma. I support our judges. I've 35 years. We got awesome judges. We got great people in Oklahoma in the court system, but we cannot allow our court system to be corrupted, and these people need to be held accountable.
All right, Ken, I'll give you, we have about 40 seconds left here. I'll give you the final word.
I just think it's a disservice to these judges who did what they had to do under the law that was there to protect minors from being held accountable as adults. Now, your other guest, Representative Humphreys, worked for DOC, retired from the Department of Corrections. He knows how abysmally evil that place is, and we don't need to be taking 16 and 17-year-old people and putting them in there because they're going to get out. They're going to eventually get out, and they produce defective products. We give them the raw materials of accused criminals, convicted criminals, and they come out defective. And this process is to help protect children. Now, if he messes up, he's gone. He's going to prison. He's got to do what he's supposed to do. And there's more to the story that we will never know because they're juveniles, they're minors, and there's stuff behind the scenes. I'm just saying, looking at these pleas and the way it played out, there's something else going on here that is not corruption. And I think it's easy to say corruption, but it's different. It's easy to make an allegation, but it's very difficult to prove an allegation.
All right. Justin, I'll give you 10 seconds. Go ahead.
Yeah, I've got abundance of proof. I agree with the judge on the prisons are bad places for bad people. But if you rape 2 women and you're 17-year-old, I think you need to be held accountable. I've got a young man, Eric Proctor, that got 330 years for aiding and abetting rape here in Oklahoma. So we'll give a juvenile. He was a juvenile also. I agree with the judge. We need to clean up our prison, and we need to have evidence. It's easy. I agree with him. You have evidence. I'm a guy who goes to court a lot. I wouldn't bring forward and call corruption if I didn't have evidence. I agree with everything the judge is saying, but I do have evidence.
Gotcha. Ken Adair, Justin Humphrey, appreciate your time and your passion. Still to come, why was this arrest handled with kid gloves?
Is this 17-year-old boy, yes, again, I said boy, he ain't a man. How is this boy getting away with this? Just because of his connections? Yeah, as you can see at the the bottom left of your screen, I put this in the chat that this was complete and total bull. I gotta agree with Justin Humphrey, especially when I found out that there was someone who was charged with aiding and abetting rape and got a whopping 330 something years in prison for aiding and abetting. But this boy has gotten what? A few hours of community service, a slap on the wrist, and that's it. And mind you, there was no sexual intercourse committed. But still, he was charged with it, and this is all he got. He could have done the full 78 years if they had done it right. Or just the 10, but that still wouldn't have been satisfactory. Now, I'm going to get ready and go into the next portion of this, and where we ask the question, why was the arrest handled with kid gloves? Let's find out together why it was handled this way. I mean, yeah, he was a minor at the time. He's 18 now. And just like I told my wife, Lady Outlaw, off camera, when the moment he turns 19, it's those charges will be like it never happened. Let's go back to VPI.
I'm Vinny Politan, and we continue our investigation of the violent sexual attacks of 2 teenagers and an offender who was given a break and escaped true punishment for his crimes. Here's the story.
In the heart of Oklahoma's college town, neighbors were rocked by the revelation that star teen athlete Jesse Butler was accused of a campaign of sexual violence against 2 teenage girls. He pleaded no contest to 10 rape-related charges, including a count of violating a protective order. His victims' voices filled with pain and with fear. The video, the medical reports, the phone records all told a story of cruelty and suffering. Yet, when the sentence came, outside the courtroom, families wept. Under the youthful offender law, Butler's 78-year term was suspended, and he remains free under supervision until he turns 19. Protesters flooded the courthouse demanding the system protect its girls. If brutal sexual assault doesn't demand some prison time, what does justice truly mean?
I told you at the top you'd be shaking your head all hour. Let's bring back in Court TV field reporter Cody Thomas, help us walk through the story. Now, let's talk about the day he gets arrested. What are the circumstances surrounding his arrest?
Well, Vinny, of course, there were 2 victims who were in romantic relationships with Jesse Butler for a few months each, who initially brought these allegations against him. But before we get into those circumstances surrounding the arrest, let's take a look at that body cam video from the day he was arrested in March of 2025.
We're ready to obviously tell our story too.
Yeah.
Jess, it's Mom. Open the door. It's me.
And if you'll just have him step out, then.
Give me your wallet and phone and stuff. So, okay. Your what? They're in the car. Well, okay, it's fine. It's not locked or anything, is it? Okay. So, can you tell him what you just told me, or?
Yeah, so we're here. We're obviously going to place you under arrest. There's a warrant for your arrest. We're going to take you to the jail. I told your mom that she can contact a bondsman, and you shouldn't be very long, but there just is a process for paperwork and stuff. But right now you do have to come with us, and I do have to put you in handcuffs. So turn around for me.
You have to put him in handcuffs?
Requirement for us to come transport somebody in custody.
You know we're going to win this. It's okay.
Here,
Yeah. I'll get you out for me. All right, stay silent. Rick knows about this. Candy's on this. Dad's on his way. We're coming to get you, okay? Stay strong, okay? Say your prayers.
Okay, so he's going to go right to the city of Stillwater jail, and if you'll just contact her, then she does this all the time. She knows what to do.
Yep.
Make sure
Okay.
she knows Stillwater Police Department, not a county.
Stillwater Police Department on Lewis.
Yeah.
Yeah.
Let them know that we're the ones that picked him up.
And
They
when
don't-
you say we are the ones.
Stillwater PD.
Stillwater PD.
Yeah.
Okay.
That way they don't think he went like straight over and he's over at the county.
Awful experience for a child.
Ready to pass the team. Yeah. Get that chart. I'll pat you down. Spread your feet for me. Nothing in your socks.
Yeah, Vinny, so police seem a little gentle there given the heavy circumstances here, but let's talk about the first victim. Now, she was underage, so she was not named in the arrest affidavit, but the document shows that she and Butler dated from January to March of 2024. On September 12th of that year, a school resource officer took a report from the victim who says Butler twice attempted to rape and assault her. And after an investigation, several other sexually violent incidents were presented between Butler and the victim in February of 2024. All of that, of course, according to the affidavit. Now, the second victim dated Butler from March to September of 2024. She reported her incidents to the school resource officer at the same time as the first victim. Now, this victim's allegations concern domestic assault and battery by strangulation. An investigation into her story found more instances of physical aggression and violence, so much to the point where this victim said she felt coerced to have sex with Butler to avoid being strangled and further abused. Now, Jesse Butler was 17 years old at the time of his arrest. He's 18 now, but let's take a look at the charges he faced when he was arrested as outlined by the arrest affidavit. Now, for the first victim, you have domestic assault and battery, a misdemeanor, followed by several felonies, including domestic abuse and strangulation, sexual battery, rape by instrumentation, sodomy, attempted first-degree rape, and kidnapping. Charges related to the second victim include all of that except the first-degree rape and the kidnapping charges. Now, we know that Butler pled no contest to the 10 rape-related charges and is serving, of course, that suspended 78-year sentence without being behind bars, Vinny.
All right, what a contrast. Cody, thanks so much. Great work tonight. And the contrast between the level of these charges that the arrest is for and the nature of the actual arrest. And it brings us to the next question in our investigation. Why was this arrest handled with kid gloves? Is it because he's just 17? Here to help answer that question is Pascal, the host of The Pascal Show, and former law enforcement officer and host of the Strong Enough podcast, Claudia King. Claudia, I'll begin with you. You saw the list of the charges. That's what the arrest is for. And then we all watched the way the arrest went down. Why do you think that he was treated that particular way? Is that normal? Is that not normal? Is it because he's 17? What are your thoughts about how that arrest went down?
My thoughts are the arrest went down that way because of influence. I believe that the Mack family clearly is influential in that community. They know other people who are influential, and so they had to treat him that way or else be forced to seek retribution or see retribution in their actions from this family and from people who know this family. It was not normal how he was treated. The search was terrible, by the way, of him before they put him in the car. Just very disappointing all the way around with this case.
Pascal, what went through your mind the first time you saw the arrest video?
What a crybaby. Justice is coming, but apparently justice was not coming. You know, what's really frustrating about this is that we are consistently seeing countless times repeat offenders getting a slap on the wrist. And this is exactly what we're seeing right now. And what I fear is that the likes of this kid, Jesse, is going to do something even more violent. He's going to do something even more egregious, even more nefarious. I mean, look at the likes of Keon King. Look at the likes of Jake Haro, what he did to Emmanuel Haro. These guys were repeat offenders, and the courts, once again, were very light to them when they should have been hit with the entire library, not just the book, the whole damn library.
Claudia, when you're making an arrest, and I don't know if there's what the standard procedure is, how often does a discussion precede it? Like explaining to someone why you're being arrested and then rather than like, you know, put your hands behind your back, cuff them and explain them. Because we watch a lot of body cam videos, and this just struck me differently, but I don't know if it's normal for these circumstances. Just physically, like when he gets cuffed and when he gets told and the way that goes.
I didn't think it was normal. I mean, obviously, you always want to be respectful to the individual that you're arresting. Technically, they are innocent until proven guilty. So you want to be respectful. You don't want to purposely hurt them, but at the same time, you don't need to be all sweet and kind and talk to their mommy first and explain everything to her and let her go in the house and get him. I just thought the way that they treated him was absolutely not normal. Again, you don't have to purposely try to hurt him, but you should treat him like the criminal that he is currently alleged to be. He is a dangerous person at this moment, and that's how he should have been treated, and he definitely was not.
Yeah, Pascal, you talk about things like kidnapping and attempted rape, and these are extremely serious, yet they're doesn't seem to be that same level of seriousness at the actual arrest. Like there was, you watch body camera videos all the time too, and obviously some circumstances a little more hyped up than others. If there's a chase, I understand there was some coordination here, but still, you don't know how that suspect is going to react. It was really strange to me.
Yeah, I mean, again, this is the whole, as you said, this whole kid gloves type of thing. Instead of actually treating him exactly how he is, as a criminal. I don't understand why they would sit there and try to be kind to him. Absolutely, put him in handcuffs. Absolutely, pat him down. Do the search because he's supposed to be a criminal. He is a criminal. So it doesn't make any sense that this kid is still out here being able to be a kid.
Yeah.
He lost that privilege when he did those things to those multiple people that stepped forward and spoke out against him.
Pascal, host of the Pascal Show. Make sure you check it out on YouTube, folks. Thanks so much. Claudia's going to stick around. Coming up next, was justice served in this case?
Book, because he said exactly what I was thinking. Instead of treating that boy with the kid gloves, he should have literally have been cuffed and stuffed, and not just thrown the book at him, but the entire library. The whole thing, not one page short. Which is gonna bring up the next question on this investigation that Vinny's gonna cover, and I'm gonna go ahead and answer it right now. Was justice served in this case? My answer, no. If anything, it's justice denied. Those girls who reported this and knowing full blown well he's walking free, they're about to be prepared to be subjected to being victims all over again. That's not justice. That's justice denied. And personally, that's a bitter pill to swallow. And as a host of this particular podcast, I don't like the taste. Let's get back to the investigation.
Sunday nights on Court TV. Sunday starting at 6, 5 Central on Court TV.
Okay, let's recap what we've learned this hour. 2 16-year-old girls are systematically abused sexually and violently by a 17-year-old. The 17-year-old gets charged, goes to court, 78 years, suspended, treated as a youthful offender, ends up serving not one single day in incarceration, do some counseling, community service, age 19, he is free to go. That brings us to the next question in our investigation. Was justice served in this case? Back with us, digital journalist Justin Shepard, helping us out here, and still with us, former law enforcement officer, host of the Strong Enough podcast, Claudia King. Justin, what are your thoughts here about justice being served?
Well, I don't think that justice was served in this situation. I think that when he was facing 78 years, that was more like justice, because now what you have is you have 2 young girls, both left with a lot of trauma, emotional scars, one of them with physical scars on her neck from the surgery that she had to get because of the injuries he inflicted on her. And basically, he gets to walk out free. And when he turns 19, he's not going to be on a sex offender registry. This is going to be wiped completely clean on a background check. It'll be like it never happened to him. Meanwhile, these young girls, and they're young, you know, this is 16 years old when this happened. And you see the pictures of him in the video. He's a big guy. You know, he gets to live his life while they carry the scars and the trauma of that day, or those days, plural.
Yeah, it's so right. You know, it's a youthful offender statute that protects youthful offenders, but there's nothing there to protect the youthful victims. Claudia King, was justice served here?
Absolutely not, because as was just mentioned, these two victims now have permanent damage, trauma, scars even, to leave this story with them for the rest of their lives. And Jesse Butler has nothing, and he's already a repeat offender. That's what, you know, we forget sometimes. These were two different individuals that he was charged with. So he's already a repeat offender, a repeat domestic violence offender. So the fact that he's going to repeat again is almost certain, especially because he got off with nothing this time. So this only emboldens him and tells him in his mind that I got away with it, I can get away with it again. That's not justice.
Yeah, that photo from the New York Post that they got from the family of one of the victims in the hospital is so devastating. And Justin, what is so disheartening about all of this, they're younger than he is, and as you mentioned, they're smaller than he is, and they don't get out from under this. There's no way to get out from under as to what they had to endure. You've been shining a bright light on all this. What are your thoughts about the future, or what happens next in all of this?
Well, there's one thing that I think that's important for your viewers to know that I don't believe was mentioned yet, and that's the fact that with the two girls that came forward, as I understand, there's a third one who has not come forward because you can see why there's no justice here. Both of those girls, between the two of them that came forward, experienced 3 strangulations. For one of the girls, he strangled her to the point of unconsciousness, and when she came to, he wanted to film it, so he did it again so he could film it to that same girl. And they found that video on his phone during the search. So it's one of those things. It's very black and white. It exists. And I think that when you're looking at somebody who is strangling people for funsies to the point that they're unconscious, to the point that one of them almost dies, this is somebody who is, it's not a matter of if, it's a matter of when he kills somebody.
Yeah. Claudia, how concerned are you about that, about this same young man, now he's an adult, 18, ending up victimizing someone else?
I believe it's absolutely going to happen because, yes, when somebody does the act of strangulation, there's a higher chance that the victim is going to die at some point. He's just trading out victims. So the chance that he is going to kill somebody at some point is extremely high because, yes, he did this and then said, oops, I forgot to capture the Kodak moment, so let me go at it again. So he wanted that trophy to keep. That's a depraved mind. He is definitely going to kill somebody, and I hope that the DAs, the judge, everyone involved in this complete miscarriage of justice doesn't sleep a wink, because they will be responsible for everything he does from here on out.
Absolutely, and let's hope the counseling has some impact. Big thanks, Justin Shepard, great work on this, really appreciate it, and Claudia King, always great to have your perspective. You know, the biggest problem I have with this defendant being given another opportunity by the youthful offender statute is his history. This was not an isolated incident, not a one-off. There were 2 victims, at least 2 victims. And equally troubling is the fact that he violated a protective order. These factors, in my opinion, make this decision very questionable about allowing him to become a youthful offender. I'm Vinny Politan. We'll keep digging for answers as the investigation continues.
I gotta agree with everyone that said that justice was not served in this case. All it is just giving this boy an opportunity to say, oh great, I got away with this. That means I can do this again and again and again and again, and all I got to do is run to mommy and run to daddy. Daddy, they can't do nothing to me. It's like a case of entitlement is your first language and English being second. He's got to learn somehow. Okay, let's see what's next on the docket. Oh, now, this is interesting. Okay, let me set all this up real quick. A 6-year-old goes to a school with a gun. He shoots the 6-year-old shoots the teacher. The teacher sues the school and is awarded $10 million because of it. Now, the students that were in that danger zone are going to sue the former assistant principal for the same thing. Here's a breakdown. Students who witnessed a 6-year-old classmate shoot their teacher are now pursuing their own lawsuit against the former assistant principal who was accused of failing to act on warnings about the gun. Emily Brannon, representing multiple students from the January 6, 2023 shooting at Rich Neck Elementary School, announced the lawsuit on Court TV as the legal fallout continues from the incident that left teacher Abby Zwerner severely injured. The student's lawsuit against Dr. Ebony Parker follows a jury's award of $10 million to Zwerner last week, which found Parker liable for ignoring multiple warnings throughout the day about the student possessing a gun. These children were traumatized by what they witnessed, Brandon said. They have a right to seek accountability for the harm they suffered. The student's case is separate from both Zwerner's successful civil lawsuit and the criminal charges Parker faces. Parker is scheduled to appear in court on November 17th for her criminal trial on a felony neglect charge. That's next Monday for those of you keeping track. During testimony in the civil proceedings, the court heard how Parker received at least 4 separate warnings about the student having a gun, but took no action. School counselor Rolonzo Rawls testified that he asked Parker for permission to search the student after another child reported seeing bullets and being threatened. Reading specialist Amy Kovac also testified that she reported the student's concerning behavior to Parker, who acknowledged it but failed to take action. The shooting occurred around 2 p.m. when the 6-year-old pulled a gun from his jacket pocket and shot Zwerner. The bullet traveled through her hand and into her chest, causing life-threatening injuries that required multiple surgeries. Parker's defense maintains that the shooting was unprecedented and unforeseeable, arguing that no one could have predicted a 6-year-old would bring a loaded weapon to school. Seriously? The student had a documented history of behavioral issues, including an incident where he allegedly choked another teacher. Parker was terminated from her position following the incident. She has served as assistant principal at Rich Neck Elementary, where she was responsible for student discipline and safety protocols. Seriously? 4 warnings, 4 of them, and you ignore every last one of them? let's go to Court TV for further coverage of its interviews regarding this. This is just absolutely. I don't even know how to describe this.
I just remember her facial expression. It was kind of like a look of shock.
Once you heard the shooting, what did you think that was?
I knew it was a gunshot.
How many times was she shot? How many gunshots did you hear?
I thought I had died.
Do you have any opinion on whether Dr. Parker could have foreseen JT's actions that day based on the information that she had?
I think it would be difficult for anyone to have foreseen that.
Well, it could be tipping the scales in the criminal trial for the first grader shoots teacher case in the case against Dr. Ebony Parker, the former assistant principal of a Virginia elementary school. Abby's Warner, the teacher who was shot by the 6-year-old, won her civil case. We watched that play out here on Court TV.
We, the jury, on the issues joined, find in favor of the plaintiff, Abigail Werner, and assess her damages at $10 million. The award interest beginning on June 1st, 2024.
That was $10 million. It wasn't her money. You know, I'm sure she was a little disappointed by the civil jury's verdict, but now the criminal proceedings are ahead, and she's charged with 8 counts of felony child neglect. What can we expect at the trial? How might witnesses here play a factor into this criminal courtroom and civil night and day? We have with us an attorney representing many of the students, 8 of them, and an adult. Let's bring her in here to discuss. Emily Brandon. Emily, good morning to you. First, what is your connection to the case? You're representing students, these 8 students. What's your role? What's the student's role and the adult that you represent's role here as we move forward towards this criminal proceeding?
Thank you, Ted. Yes, I represent 8 students who were witness to the shooting in the classrooms, and I represent an adult who was actually on school grounds that day to pick up a grandchild and ended up in the melee in the front office and actually did render some aid to Abby during the commotion before first responders arrived. And the basis of those lawsuits is related to the emotional pain and suffering, along with some physical injuries such as sleepless nights. We've had some kids that have experienced bedwetting, flashbacks. Most of them have been diagnosed with PTSD following this event. And so that is the nature of the cases that I have, which are civil in nature.
And is the assistant principal named in this, or are you just the district? Is the same scenario as we saw with Abby's lawsuit?
It is the same scenario as Abby's lawsuit. However, in my case, everyone is still in the case. So in Abby's case, right before trial, I think back in maybe July of 2025, there was a hearing, and the school board and Dr. Foster Newton were both dismissed from the case, leaving only Ebony to stand that trial that you just finished up last week. In my case, we haven't made it yet to those motions, and so every entity is still in my case as a defendant.
Gotcha, makes sense. Let's talk about the criminal case that is ahead here. What are your thoughts? I mean, the civil, I get you'd sue her, but should this woman, she had a horrible day at work, she made every wrong decision you could argue, should she go to jail or prison for that? What's your take on the state going after her criminally?
Well, I think it's important for people to know that this was a very special proceeding that happened in order to bring these charges, which was a special grand jury. So in Newport News, they convened a confidential, I believe, special grand jury, and they heard evidence over a course of about 2 to 3 weeks, which is essentially like a trial, but with a lot less of the rules. And their job was to determine if they felt, based on that evidence that they had heard, was there enough to bring these charges? And they decided yes. And I don't know if you've read the report that they wrote, but it was scathing. I have never seen a grand jury, special grand jury report with such detail and frankly emotion. And I was there during those proceedings because some of my clients gave testimony in that special grand jury proceeding. And it was really hard to hold back tears from most of the people in the room when you heard from these parents. And so it's a tough question to answer because we're all human and we certainly have sensitivity to and sympathy for an individual who's facing so much for this one event. But wow, obviously a group of her citizen peers felt that she failed these children and she failed everyone in the school that day. And that's why these charges are here.
Your 8 students that you represent, and how many will be testifying? How do you prepare them? I mean, will you be there? Do they have to testify? What do you know now, and what are you getting ready for?
Sure. I have at least 4 clients who will testify in the criminal trial. They are prepping with the prosecutor in that trial because, as you know, the prosecutor is the lead attorney in that case. He is bringing the criminal case against Ebony on behalf of our Commonwealth. And so I have a role in that in the sense that I'm helping my clients navigate, which is what is a very scary process, but I don't have a role as an attorney in that case. But I will be there standing beside them, especially those that are speaking. And they've been prepping over the past 2 weeks. Some of them won't testify. And it won't be any children. It will be parents and adult witnesses.
Okay, great. There's no kid. I mean, the kids were so young. One would hope that they wouldn't have to endure that. Let's listen to some of the employees at the school that testified during the civil proceedings. You could feel the emotion from them. Take a listen.
What did you do after you heard the frantic call? I know, Mr. Rawls. It's okay.
He shot her. And I said, he did what? And she said, yeah.
Did you hear the shooting?
Yes.
Okay. Once you heard the shooting, what did you think that was?
I knew it was a gunshot.
And where did you think it had come from?
Abby's room.
A 6-year-old, it's so hard to get your head around. That was part of Dr. Parker's defense, which I'm sure we'll see play out in the criminal proceedings as well. A 6-year-old we don't think should have a gun and not bring one to school and not be able to use it. There's so many things that you can't get your head around. And that's what you saw there, that emotion. Do you expect that to play out again in the criminal proceedings?
Yeah, absolutely. That was Rawls that you just played. I was moved by his testimony as well because I know they're all just people that were at their regular job that day. And I know that these other teachers feel some level of personal responsibility. And I have to say, this is probably unpopular opinion, but the takeaway for me from the civil trial in the last 2 weeks, as I watched it in live, by the way, I really am grateful we had that opportunity for Court TV to stream it because my clients could watch it from home and they didn't feel like they had to sit in that courtroom with all of the news. So that was really something great for them to be able to watch from home. But one of the first questions that I had when I learned about these cases in January of 2023, everyone's focused on Abby, obviously, because she was very, very injured and it was a serious incident. But I just couldn't help but ask myself, why didn't anyone do anything? anything. And what about these kids? Because for the longest time, we didn't hear about the children at all. It was just about Abby. And as I'm hearing about the testimony with what happened on the playground, there was a period of nearly an hour where 40 children were with a child who had a weapon, a gun, in his sweatshirt.
Yeah.
And she knew that.
Yeah, and well, yeah, it's horrible. The whole case is horrible. We appreciate you, Emily, coming on.
Dr. Ebony Parker is looking at and needs to do some time. I mean, how do you get 4 different warnings about a 6-year-old with a gun and ammunition, and you just ignore it? Which ends up with one of your teachers being shot. The teacher sued. The teacher successfully sued and got and is awarded $10 million. The students are gonna sue. Who knows if that'll result in a favorable verdict, and the former assistant principal, Dr. Ebony Parker, is going to face criminal charges as well. This is something no parent, let alone a teacher, would want to go through or have their child live through that kind of trauma. Next up, a judge rejects a plea deal in Timothy Halschuld's murder case. Maybe the judge got wind of my opinion on plea deals. Let's see what was this deal. We're in Manitowoc, Wisconsin. A Manitowoc judge rejected an offered plea for Timothy Halschuld, who's been charged with murder among other counts for allegedly ordering punishment that led to his great-nephew's death. Judge Kerry Reed said such a plea would not be the best interest of the public. Halschuld faces multiple felony charges stemming from the death, including felony murder for the death of 7-year-old Ethan Halschuld. He was first arrested in 2019. According to a criminal complaint, that is, Halschuld directed his then 14-year-old son, Damian Halschuld, to discipline 7-year-old Ethan for failing to memorize a series of Bible verses. The punishment allegedly included having the boy carry a heavy log for hours under Damian's supervision. An offered plea allows defendants to maintain their innocence but accept a conviction, according to the State Bar of Wisconsin. In February, a different judge refused to accept the plea agreement Halschuld had reached with the prosecution at the time. At that time, Judge Geraldine Dietz implied she wanted a longer sentence than the 12 years the two sides had agreed upon. Dietz later recused herself from the case after the defense filed a motion for her to withdraw. Now that the deal has been rejected, Halschuld's trial remains scheduled to begin on February 23rd. So, Timothy Halschuld wanted to offer an offered plea, meaning he said he'll take whatever punishment is given, but he'll still go on and say, I'm innocent. I'm innocent. That's number one. Number two, what could a 7-year-old boy have done aside from not being able to memorize and recite Bible verses that caused this 7-year-old's death? I mean, there are some Bible verses I couldn't remember at the age of 7, and I remembered a good deal. Hold, wait, guys, I'm gonna let my wife. She's off camera, but I'm gonna let my wife in on this. This is Lady Outlaw, ladies and gentlemen, sweetheart. You're hearing this case. 7-year-old child dies at the hands of his uncle and probably his cousin for, of all things, not being able to memorize Bible verses.
So,
and keep in mind, he's 7 years old.
Okay, so at his age, I was doing Bible quizzing. Did I get beat for not knowing the verse?
Beat? No, beat, babe, beat.
Or killed?
This kid, for one punishment, this kid was ordered to, if I'm looking at this right, carry a heavy log for hours under Damien's supervision, the 14-year-old son.
I had to do dishes.
Huh?
My dad pulled out all the dishes and made me do every single dish.
What that's not harmful to you. This kid is carrying a heavy log for hours. All right.
It is when you have to go to school the next day. Hello.
7 years old?
Yeah, somewhere around there. Yes.
I mean, I've seen 7-year-olds have a hard time reciting, and mind you, this is one of my favorite passages, ladies and gentlemen. I've seen 7-year-olds have a hard time reciting, "The Lord is my shepherd, I shall not want. He makes me lie down in green pastures. He leads me beside still waters. He restores my soul. He leads me in paths of righteousness for his name's sake. Yea, though I walk through the valley of the shadow of death, I will fear no evil, for you are with me. Your rod and your staff may comfort me. You prepare a table before me in the presence of my enemies. You anoint my head with oil, my cup runs over. Surely goodness and mercy shall follow me all the days of my life, and I will dwell in the house of the Lord forever." Now, keep in mind, I just recited that, and I'm nearing 50.
Our Father who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us our daily bread, and forgive us our trespasses. We forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thy is the kingdom, the glory, and power, and forever. Amen.
And that was Lady Outlaw reciting the Lord's Prayer. And may I?
Yes.
She is 42, which for both of us, between her passage and mine, we are a long ways from 7 years old.
42 or 41.
I'll do the math later. But we are both a long ways from 7 years old. Like I said, I know some kids at that very age who I know some kids at that age who are still having a hard time reciting certain verses. Some easy, some not so much, but they still have trouble reciting those. That does not give this man the right to punish this child to the point of death. I'm just saying. Next up on my docket. This one I kind of laugh at because I don't know much about the back end of the subject. A woman is charged with killing a pharmacy student after smoking marijuana. After smoking marijuana. we go from one end of Wisconsin to another. We're going to Milwaukee. A Milwaukee woman has been charged in the fatal shooting of a 26-year-old pharmacy student. 31-year-old Jamaica Mills was charged Saturday with one count of first-degree reckless homicide, use of a dangerous weapon, according to a criminal complaint. Prosecutors say Mills claims to have accidentally shot and killed her friend Ariel Spillner after she had become paranoid that Spillner would stab her after the two had smoked marijuana together. According to the criminal complaint, when officers arrived at the residence around 9:40 Tuesday near 39th Street and Lancaster Avenue in Milwaukee, they found Mills lying on her back with a gunshot wound to her abdomen. Spillner was found unresponsive and face down with a gunshot wound to her left shoulder and was later pronounced dead. Prosecutors says Mills was combative at the scene as well as in the hospital where she was treated for her injuries. Investigators recovered a handgun and 2 spent casings from the scene. Prosecutors allege the gun was found near Mills and that investigators also located a Ruger firearm box with purchase paperwork in her name, as well as ammunition matching the casings found near the crime scene. Her sister-in-law told investigators she was in the home at the time of the shooting and recalled hearing someone say, "Beep, you tripping," before 2 gunshots rang out. Prosecutors say Mills allegedly claimed not to remember what happened and that the last thing she remembered was waking up in the living room and then being at the hospital. Mills also claimed she and Spillner were talking about Spillner's boyfriend when she heard a shot and felt a shot, initially claiming that she thought Spillner shot her first. However, according to the complaint, Mills would later allegedly admit to retrieving a gun from her bedroom before returning to the living room. She claims to have shot Spillner after she made a hand motion, despite telling investigators she didn't see Spillner with scissors and that she hadn't made threats toward her, according to the complaint. Mills was in court this past Sunday where her cash bond was set at $150,000, according to court records. She is due back in court November 17th for a preliminary hearing. Now, I say I don't know much about marijuana, and I still make that claim. But if it's going to make you that paranoid, my opinion, don't mess with the stuff. Not messing with that stuff will least likely to make you have a different title, murder defendant. Just saying that. Next on the docket, well, we had one judge refusing to accept an offered plea. Now we have another judge in a different case refusing to dismiss charges in a crash that killed 4 Pepperdine students. We're gonna get to that. We're gonna get to that news in just a moment, courtesy. Actually, no, we won't. We're gonna get this right here with this breakdown. This is out of Van Nuys, California. Man accused of speeding and causing a crash that killed 4 sorority sisters. Fraser Michael Baum is charged with 4 counts of murder in the deaths of Niyama Ralston, Aisha Weir, Deslin Williams, and Peyton Stewart. And if I mispronounce those names, count it to my head and not my heart. At a hearing on Monday, Judge Thomas Rubison found sufficient evidence to uphold the charges despite the arguments of Baum's attorneys. Baum wasn't pushing for the dismissal of all charges in the case. Rather, he argued that he should only face charges of vehicular manslaughter. These are the same charges that Brian Kohlberger is facing, Jackson said as he urged the judge to dismiss the murder charges. Baum is represented by high-profile attorney Alan Jackson, who represented Karen Reed in her criminal trial and continues to represent her in a civil trial she faces. In September, Jackson was unsuccessful in requesting that the judge lower Baum's bond so that he could afford representation more easily. Jackson appeared at Monday's hearing with a bandaged hand. He told Court TV that he had suffered a burn. Jackson argued that speeding alone is not grounds to charge someone with murder following a crash. While prosecutors have accused Baum of driving 104 miles an hour in a 45-mile-an-hour zone, his attorneys have said the actual speed was closer to 70 miles an hour. Baum remains free on a $4 million bond pending trial. $1 million for each one of those students killed in that incident. And they want to lower the bond for him? I don't think so. Number one. Number two, I don't care if the speed was 104 or 70. If there was some other factor that caused that crash, it needs to come out. So yes, I'm with the judge in his refusal to dismiss the charges in this case. Good work on his part. Next up, Austin Drummond. Austin Drummond is indicted for 4 murders, and the prosecutors are seeking the ultimate sentence, death. All right, we'll go back to Court TV in just a matter of minutes, but let me break this down for you all first. Tiptonville, Tennessee. Tennessee man accused of killing 4 members of the same family and kidnapping a baby has been indicted by a grand jury, according to prosecutors. Lake County District Attorney General Danny Goodman told Court TV that Austin Drummond has been indicted on 4 counts of first-degree murder, 4 counts of unlawful possession of a firearm by a convicted violent felon, aggravated kidnapping, and possession of a weapon during the commission of a dangerous felony. Goodman also said his office has filed a notice of intent to seek the death penalty against Drummond. Drummond was arrested after a week-long manhunt. Authorities say he killed 4 people on July 29th in Tiptonville, then kidnapped a baby and abandoned the girl in a stranger's front yard in Dyer County. The victims were identified as the baby's parents, James M. Wilson, 21, 20-year-old Adriana Williams, age 20. Williams' brother, Braden Williams, age 15, and their mother, Courtney Rose, age 38. Investigators determined the 4 relatives have not been seen since the night before, according to Goodman. A relative had called 911 after finding 2 vehicles in a remote area, and the 4 bodies were found in nearby woods, according to Goodman. Drummond's girlfriend is the sister of the infant's grandmother, according to Goodwin. So, maybe it's possible, it's highly possible that seeking the death penalty in this particular case could very well tip the scales of justice. Let's go to Court TV and see what Ted wrote.
To know that murderers come down through here, I mean, yeah, it's scary. Who could have done that? Who could have left a baby at it somewhere with strangers outside in this heat? I mean, who would do that?
Authorities say that quadruple murder suspect Austin Drummond did that, and they say he'll be facing the death penalty. But did he really do that? Lake County District Attorney General Danny Goodman tells Court TV that Austin Drummond has also been indicted on 4 counts of first-degree murder, 4 counts of unlawful possession of a firearm by a convicted felon, aggravated kidnapping, and possession of a weapon during the commission of a dangerous felony. He's accused of killing 4 family members. It's horrible. Then taking an infant and not killing the infant, abandoning the infant in Tennessee, basically saving the infant's life in this chaotic situation. But the questions people have is, could there be other people involved? We know he has a history with the Vice Lords gang, and he was exposed as a prison snitch. So the alternative theory here is that this was the gang sending a message. Now, Austin Drummond, not exactly a model inmate. He says his behavior behind bars in the local jail includes covering his cell door with feces. And guess what? And he's been a problem. He was moved to a state prison while he awaits trial. Very rare you see that. We saw it in the Richard Allen case up in Indiana. They moved him to a state prison, not because of his behavior. There's a question of why they moved him. But in this case, they didn't feel comfortable with him in the county jail, so now he's at the prison. He's facing the death penalty. Criminal defense and civil rights attorney Casey Early is still with us, and criminal defense attorney Franz Borghardt. All right. Death penalty. He does have this weird, like, okay, he saved the child, so people maybe think, Franz, you shouldn't charge him with the death penalty. You shouldn't go after the death penalty because of that one good deed that he did. What are your thoughts?
So in our country, in most of the states at least, 1 vote for life is enough. 1 vote for life in the penalty phase is enough to give someone life in jail and not the death penalty. And that vote for life can be based on any mitigator, any reason under the sun that one juror wants. And to your point, Ted, that one saving grace of this individual might be enough to get that one juror to vote life. It certainly doesn't necessarily exclude him from being a candidate to being prosecuted for the death penalty. And look, I'm not saying that at some point they won't offer him a plea for life, but he's in a really, really precarious ship right now that has a lot of sinking holes and leaky parts to it. So candidly, if I'm on his legal team, I'm trying to find any reason in the world to get to life.
Yeah, Casey, he's got the state trying to kill him. Apparently the Vice Lords, maybe because he's a documented snitch. He's in a world of hurt. Do you foresee this thing maybe pleading out before trial? Because on from the state's standpoint, this gang activity and him being a snitch, it could be used by someone like Franz, who says he'll do anything for his client, to create some reasonable doubt, right? That maybe the Vice Lords did it. This was a statement. Who kills their, cousins and their relatives? Your thoughts?
That's what I'm thinking. I mean, you don't need motive, but you certainly need to prove your case, each and every element, to the exclusion beyond a reasonable doubt. So what are the elements and what is the evidence that's attached to it? I mean, this is a good case for the defense if you want other alternatives, other explanations. Like you said, the Vice Lords, that's a gang. They're known to kill relentlessly, and they're known to do that to family members that are closely attached to their subject. And then you have that he was also a prison informant for law enforcement. So who knows who could have had a hit out for him. So there's so many holes that the defense can poke into the state's case in chief that can possibly save his life. But on the other side, if he is found guilty, I don't see the fact that he, quote, saved the baby is sufficient to spare his life, because he took 4 lives, right? So if the death penalty is not enough for being found guilty, although I personally do not believe in the death penalty because we know that the system is flawed and there's innocent people that are found guilty all the time. But this is the law that we live in, and if he's found guilty based on the overwhelming evidence, then that may be sufficient for that, because there were 4 lives, and condolences to the family.
Yeah, absolutely. One would think on paper there is that. There's also you could argue, I mean, if he's off his rocker putting feces on his door handle at jail, that could save his life too. The penalty phase. There's a lot going on here. Death penalty conviction. As we saw, Nicholas Cruz, Brian Kohlberger, I mean, he got out of the death penalty. It's definitely not a slam dunk by any means. Let's listen to the defendant in court saying, I want a speedy trial.
As long as it's not related to the facts of your case or anything that could infringe on your Fifth Amendment rights, I'm fine with that, sir.
I'm just wondering, is now the time we need to ask for a quick and speedy trial? How's that?
Well, now that I've appointed you counsel, any motions that will be filed will go through your attorney, sir.
Yes, sir.
Yes, sir. Yes, sir. Okay.
Franz, he wants to go to trial. He wants this done. Your last thought on this one?
He needs to slow down. This idea that he needs to go to trial quickly and speedily, while it sounds very, very great, if I were him, if I were advising him, I would really encourage him to slow his roll and let the system play out. He's not going anywhere, Ted. He's not getting out of jail anytime soon. And expediting a conviction and possibly a death sentence is not something that I would encourage him to try to accomplish.
Yeah, one would think that time is always going to be on a defendant's side, especially in a case like this, which is so horrific. 4 lives lost because of, according to the state, his actions.
Never heard of a defendant in such a rush to get his case over and done with, or literally, like Franz said, he's trying to get this done, probably reach prison or death, one of the two, quick. Like Franz said, if I were Austin Drummond, or at least his attorney, I would advise him of the same thing. Slow your roll, son. Slow your roll. Let's see now. The father of the Skelton brothers is going to be released 15 years after the boys vanished. That's next on our docket this evening. We're going to Ionia, Michigan. The father of 3 brothers who went missing the day after Thanksgiving in 2010 is set to be released from prison later this month. In 2011, John Skelton was sentenced to 10 to 15 years in prison for unlawful imprisonment charges connected to the Skelton brothers' disappearance. Department of Correction records show John will be released on November 29th, which also marks 15 years and 4 days since his sons were last seen. Earlier this year, a Michigan probate judge granted Tanya Zuver's request to declare her missing sons legally dead. The boys, 9-year-old Andrew, 7-year-old Alexander, and 5-year-old Tanner, were last seen alive on November 25th, 2010, when they were playing in the yard of their father's Lenawee County home. The next day, Zoovers tracked John down to a nearby hospital after she didn't hear from him about a pickup time. That's according to Scripps News West Michigan. John was being treated for a broken ankle and reportedly told hospital staff that the injury happened while he was trying to take his own life. During the investigation, John told police that he gave the boys to an organization to protect them from Zoovers, accusing her of abuse. Still, investigators have never been able to verify that the group exists. Police say John provided other conflicting accounts of who he gave the boys to. At the hearing earlier this year, Zoovers and law enforcement officers testified there was no doubt in their minds that John had killed their sons. But Judge Catherine Sala said she could not reach the legal conclusion that John murdered his sons based on the speculative and circumstantial nature of the evidence and the investigator's opinion, noting it was based mainly on hearsay. John Skelton is currently housed at Bellamy Creek Correctional Facility in Ionia, Michigan. 3 brothers missing, and the three brothers declared legally dead, and there is still no possible anything that's showing otherwise. So the question still lingers, even though he's getting out in the next, next week or so? Next couple of weeks, right after Thanksgiving. Did he or didn't he? Only God knows for sure. Only God knows for sure. Next up, we're going to go right into our Justice Served file. A Kansas woman is sentenced for torturing and killing her 6-year-old adopted daughter. Oh, this is going to be good. A monster gets put away. I like it. Yes, we Okay, guys, what I'm going to do is I'm going to take you into this case. Let's see exactly what this woman is accused of, what she was convicted of, and what is her punishment. As you can see before you, this is Kansas versus Christina Schroer.
And during that time, I found that this woman is nothing short of a monster. And this is the exact dimensions of the box in which she was killed. And I wanted people to be able to see what that looked like, what Christina did to this child, placing this child in this box through fear and coercion. And that's the thing, it wasn't beatings, typically, that we would see bruises on. She put everybody in her life in fear. And she placed this child in a box out of fear. And then that child got into the box thinking that she'd get out, as she had so many other times before. But Christina was angry that day and placed blankets and a crib and a number of other things on there to reduce the airflow and increase the heat.
Well,
Welcome back to Court TV Live. I'm Michael Ayala.
And I'm Judge Ashley Wilcott. That was Rose Hill Police Chief Taylor Parlier sharing a disturbingly visual image of what happened to the victim in the child buried in the backyard case out of Kansas. 6-year-old Kennedy Schroer, whose biological name was Natalie Marie Garcia, disappeared in September of last year. Now, after an investigation into her adoptive parents, investigators found the little girl's remains buried in the backyard. The investigation also revealed that Kennedy had likely been dead since November of 2020 and that she had been tortured and abused.
Christina and Joseph Schroer were both charged in the case. Now, he pleaded no contest to 2 counts of aggravated child endangerment. He'll be sentenced on December 3rd. Christina pleaded no contest to second-degree murder and child abuse and was in court yesterday for her sentencing. That's what we're going to bring you today. And right now, we're going to take you into court as the prosecutor lays out the details of this tragic, tragic case.
There's a young girl, Natalie Maria Garcia. She was born July 14th, 2014 in Tulsa, Oklahoma. The little girl would be 11 now had she remained living. In August of 2017, Natalie Garcia and her 2 biological sisters were placed in foster care with Joseph and Christina Schroer. The Schroers, who were residents of Rose Hill, had a household that included biological, foster, and adopted children. In November of 2019, the Schroers adopted 5 girls, including Natalie and her sisters. Now, following that adoption, Christina removed the children from therapy. She removed them from in-person schooling. She cited concerns for an immunocompromised individual in the home. It's adult dependent. And as part of that adoption process, changed Natalie Garcia's name to Kennedy Schroer. So the name Kennedy Schroer sometimes is used interchangeably in this presentation, but Natalie was her birth name. Well, following that adoption, Your Honor, Christina Schroer established an environment of extreme control, isolation, abuse. It included things like surveillance within the home. There were multiple interior and exterior cameras that were installed in the home to alert Schroer of any movement, especially of the adopted children. She exhibited control and punishment over these kids. Even minor movements at night resulted in harsh punishments. The children were forced to lie motionless, confined in closets, dog crates, eventually locked in boxes or plastic storage containers. And then there was also the psychological manipulation that was evidence in this investigation. Schroer used intimidation, favoritism, deprivation to maintain obedience and created a system where the children were pitted against one another, even for survival. Well, in this case, the investigation determined that Natalie was last seen alive on or around October 31st, Halloween of 2020, 5 years ago, and was subsequently murdered sometime thereafter, November 2020. And what happened that day was that Christina Schroer placed a 6-year-old Natalie in a reinforced cardboard box. And I want you to understand the dimensions of this, Judge. 16.5 inches by 14 inches by 12.5 inches for punishment, and that was for moving during the night. Schroer added heavy objects atop the box. It reduced airflow, raised temperature in that box. And then on top of that, Natalie's sister was then ordered to watch the box and report when she stopped moving. That was the goal, was that Natalie or Kennedy was to be there motionless. When she did, Schroer ended up kicking the box, caused Natalie's unresponsive body to fall out of that box. She later placed Natalie's body into her vehicle, drove her around for several hours. She reported that she was taken to the hospital, but she didn't. And then ultimately returned to the home and buried that child's remains in 2 trash bags in a shallow grave right outside of her master bedroom window. Now, immediately after the murder, Schroer fabricated a story that Natalie had attacked a sibling and was removed from the home for psychiatric treatment. That's what she told her husband. That's what she told a number of different people. This false narrative was repeated over and over to relatives, friends, authorities for years. Despite earlier reports of possible abuse, Schroer's manipulation and control led investigators and family members to believe her accounts. It was consistent. The absence of visible injuries and the children's fear prevented earlier discovery of this homicide. Because understand that the way that the control happened in the house wasn't bruises, cuts, etc. It was more psychological and deprivation based. So, following Natalie's death, Schroer's abuse of the remaining children in the home intensified between 2021 and 2024, including, again, the same confinement in boxes, closets, and tubs for extended periods. Physical beatings at this point, including beatings with hands and objects, were reported by siblings. Suspension by the wrists, stabbing with sharp instruments has been outlined by some of the victims. Food deprivation, including moldy or contaminated meals. Psychological abuse, including manipulation, enforced isolation, the use of fear-based control. These were the tools that Christina Schroer utilized. The children's health deteriorated severely. The weight for age measurements on these kids fell from normal ranges in about the 75th percentile to below the 5th percentile by 2024. Schroer further fostered distrust and conflict among the children by rewarding betrayal, punishing loyalty. And this wasn't where it stopped. Understand there's a financial component to this as well. Christina Schroer exploited the foster and adoption system for financial gain. She fabricated medical and behavioral conditions such as aggression, self-harm, developmental disorders to increase, first of all, the state subsidies for her care, for child care. And these same false claims have been made regarding previous foster placements. So once those numbers are inflated and the adoptions finalized and the subsidies ceased, Schroer ended the children's medical and therapeutic care. So the investigators determined that Schroer oversaw multiple income sources, including military retirement, disability payments from her spouse, foster and adoption stipends or payments that she got from the state, SSI for the adult dependent that lives in her home, and then there were online sales and baking income that she refers to in her PSI statement, actually. And when we looked at the financial records here, we saw that just in one casino that Schroer had lost over $4 million in the process to one casino and online gambling. That was offset by about $1 million worth of winnings. But all of these monies went towards supporting a gambling habit, amongst other things. So the homicide came to light in 2024 after Schroer attempted to preemptively control the narrative a little bit more and amid growing suspicion. Investigators recovered Natalie's remains buried on the property. We came across this and the investigation really, at that point, fully was underway. And what did the investigation result in? We saw systemic failures in recognizing prolonged abuse. We saw manipulation within a closed household, tightly controlled closed household. The deceptive environment that Schroer created allowed her to conceal severe abuse and homicide for nearly 4 years. And so we're here today for sentencing. And while this, the sentence that you'll impose here today can't restore Natalie's life, it can't undo the suffering inflicted on her siblings, it does at least ensure Christina Schroer will remain confined and unable to harm others, specifically children. The surviving children are now under care. They're beginning their recovery process. That has been an uphill battle, to say the least. And I don't think for the purposes of today's sentencing that the details of that have been fleshed out, but, or will be, but that's still a work in progress very much, Your Honor, as you can understand. With me on a number of occasions, the importance of vigilance and reporting, review of abuse claims, especially in cases where caregivers exert high levels of control and isolation. We need more oversight. And so, Judge, kind of in conclusion of my statements here today, the homicide of Natalie Marie Garcia, or Kennedy Schroeder, as she was also known, represents, to me, a profound tragedy of abuse and manipulation. Christina Schroeder's actions in particular were motivated by control, financial gain, and more than anything, cruelty. It led to the death of a 6-year-old child, a little girl, years of suffering of others that were in her care. And while our efforts to achieve justice in this case can't erase this pain, the case does underscore as I said, the need for stronger oversight of foster and adoptive systems, heightened awareness of coercive, isolating family environments, such as what the Schroeder home was in Rose Hill for a number of years. Thankfully, Natalie's surviving siblings are free to heal, and they're on their path. And their abuser is going to spend the next several years confined, living in what I would refer to as a box of her own design. Her food will be controlled. She will be restricted from where she can go. Your Honor,
Jenny, were these child needed care cases involving these young girls handled through your office and the court system here or in another county or community?
The original was handled elsewhere. Since this investigation began, we've had active cases with regard to the siblings that were in the home.
We will come back to that sentencing, a horribly tragic case. I know we're going to talk about it a little bit later on in the show. Before we take a break, though, we want to turn our attention to New York, where we just learned new details about Diddy's life behind bars. According to prison documents, Sean Combs is spending his early prison days working in the chapel and enrolled in an intensive drug treatment program. That program could shorten his sentence by up to 1 year.
But we'll see how that turns out, because he also found himself facing disciplinary action for an unauthorized phone call just days after being transferred to a federal prison in New Jersey. As a result, he may temporarily lose his phone and commissary privileges. Combs was moved to the Fort Dix prison on October 30th after being sentenced to more than 4 years on prostitution-related charges.
All right. He also allegedly made homemade wine in jail, even though he'd said in court he was clean and not drinking.
He was sober. So again, as I said, we'll see if he'll get that early release.
Agree with you.
Stay out of trouble.
Right. We need to take that break now. Up next, the victim's family, including her biological mother, make emotional impact statements, and we hear from the defendant herself and who admits to wrongdoing, and she also tries to clear her husband's name.
Oh, so the man accused
I want to be a good steward of time here, so what I'm going to try to do is push this forward to the actual sentencing from the judge, and we're gonna then I'm gonna bring my commentary on this monster of a mom, as far as the as far as what she did to her adopted daughter and the sentence she gets for it. So I'm gonna bring this here. No. There we go. That's what I want. right, give me just moment, another moment or two. Okay, there we go. All right. Okay, guys. As promised, we're going right directly to the sentencing right now.
Welcome back. We are wrapping up our coverage in the sentencing hearing for Christina Schroeder in the child buried in the backyard case out of Kansas.
All right, let's head back to court now. The judge is sentencing the defendant on other charges as well.
For the second count, count 2, abuse of a child, knowingly torturing or cruelly inflicting punishment to a child. I am imposing the maximum sentence that I can give you, which is the aggravated sentence of 34 months with the Department of Corrections. These are separate and distinct offenses, and I am going to run this consecutive to the second-degree murder sentence of 165 months. On count 5, making a false writing to procure monies, welfare fraud, I am imposing the maximum sentence that I can give you for a criminal history score of I, which is, in your case, no prior criminal history, of 9 months with the Department of Corrections. That is a level 8 non-person felony that you are being sentenced for. The primary base offense of murder controls your sentence today, but I will note for purposes of the PSI, the post-release duration on an abuse of a child is 24 months, and on making a false writing, it's 12 months. As they run consecutive, perhaps the good time credit matters as you complete the murder charge and sentence that you've received by the court. Then you will serve the sentence on the abuse of a child that's ran consecutive by this court, and then you will serve the 9 months aggravated sentence on the false writing with what turns into the possibility of 20% good time credit if you earn it, if it's earned. Again, that's within the exclusive control of the Department of Corrections, Kansas Department of Corrections. Finally, on count 6, property or services by deception, failing to report that Kennedy was no longer living, no longer in your care, and no longer in your custody, yet receiving benefits for her. I impose the aggravated sentence of 7 months with the Department of Corrections, consecutive to the other count. on the level 9 non-person felony. It is 12 months of post-release supervision and 20% good time credit as documented in the pre-sentence investigation. You under KSA 215403 and general registration provisions under 224906. But I am ordering that again today. Requires that I give you jail credit for the time that you've served in the county jail as your confinement from the date of your arrest on February 3rd of 2025 to today, which is 280 days jail credit that you're entitled to have credited against your sentence, which by my calculation is an aggravated sentence of 215 months with the Department of Corrections that you're ordered to serve. I'm also ordering that you make restitution. That is a judgment that will be against you. It's a civil judgment, and it's an order in your criminal case to be considered as part of your post-release supervision or any other manner or means in which the state wishes to collect this money back from you, which I believe is in the amount of $13,413.82. Also, pursuant to KSA 20-370, I'm ordering that you pay an assessment fee of $400 to the Children's Advocacy Center Fund in the state of Kansas through the clerk of the district court, as well as court costs in this matter. The court could find you on the theft charge, but the court has to assess your ability to pay as it relates to attorney's fees and bids fees and any other fees or costs associated with this case. Obviously, you will be confined and not be gainfully employed. And so the court is not adding
on any additional fines other than the restitution. And again, that's consistent with the plea agreement, in this case, and the recommendations by the county attorney. With regard to attorney's fees, State of Kansas versus Robinson requires me to assess your ability to pay attorney's fees. Typically, that's associated with probation and someone that's gainfully employed. And so the court is required to waive those fees if I cannot make a finding that you're gainfully employed and capable of repaying the attorney's fees for the attorney that you were afforded in this case. He, of course, will be paid by the state of Kansas, but I cannot assess any costs against you with regard to that in my assessment and based on Supreme Court decisions and case law. And that will include the bid's fee as well. I'm not aware of any other financial requests for the court to impose. Again, this case is much more than finances. This case is a tragedy. And you will be incarcerated and confined for the maximum period by law that I can give you today, I have imposed. You may be seated.
All right, so Judge, she was sentenced to 18 years total on a number of charges: a second-degree murder, aggravated abuse of a child, a couple of financial fraud situations, restitution as well for the money she stole from the state, and as far as the welfare fraud is concerned. We were both concerned that it didn't seem like enough, but the judge made clear, under the law, she sentenced her to the maximum that she could.
She did, and she found there were aggravating circumstances, so she even utilized the sentencing structure for that.
Absolutely, the consecutive sentences. Let's bring back in our guest. Still with us to discuss, criminal defense attorney Dwayne Cates. Dwayne, want to get your reaction.
Well, you know, she sentenced her to the max that she could give her on every single count, and she ran them all consecutive. So there's nothing more she could have done to give her more. And by looking at the judge's face during the sentencing, I believe she would have given her more if she was able to.
Yeah, we were discussing whether or not she had tears. We had a person covering this who suggested that she was close to tears while she was delivering that sentence. But I have to ask you this: at the end of the day, yes, it's the max sentence. Is it enough? As she has available time for good time credit of 15%. Yes, she has to register with the abuse registry for years after she serves the sentence. But is it enough for somebody who did this to think that she's going to serve less than 17.9 years at the end of the day?
And you just don't know, okay? Because again, what she did was horrific. It really was horrific. But I argue all the time as a criminal defense attorney that sometimes by giving somebody an extra 10 years doesn't really do anybody any good. It's vindictive, okay? And again, she deserves punishment. And I believe that her life in prison, given what she did and the high profile nature of this case, is not going to be easy. I don't think she's going to be one of the favorite inmates on the inside. I think she will be ostracized and possibly beat up. So she's going to have a pretty rough go of it. And again, it's all part of the plea bargaining process. You know, that's the plea they struck, and that they knew that this was going to be the outcome. And this was kind of chosen by everybody, so we kind of just have to live with it.
Yeah, it's the way the system works. And I would say generally it worked under these circumstances. Perhaps longer sentence would have made us feel better, but I agree with you. I think it worked. Quickly, the husband will be sentenced on December 3rd. He's got charges of aggravated child endangerment and some other charges as far as fraud is concerned. Do you find his culpability to be the same, or were you surprised where she was saying he didn't know anything about it.
She was trying to lessen the blow on him, and I believe that she was using the same techniques to manipulate him as she did to manipulate the children. I believe he bears some responsibility into this. This happened in his house under his roof, but I believe that she was so manipulative and such a narcissist that she was able to convince him that the child wasn't at a psychiatric facility. Had to know what was going on with putting the children in boxes and the discipline techniques. Therefore, he deserves some punishment, and he'll get some.
Absolutely, and the manipulation by her is astounding. All right, thank you so much, Dwayne Cates, for being with us today.
So Christina Schroer gets 17.9 years. Let's call it 18. Minus 280 days credit for 280 days jail credit. That's what they're calling it. But the thing is, the judge said herself that she sentenced Christina Schroer to the maximum that she was able to allow under the law. So just by on that motion, I'm thinking justice served, maybe, but it still ends up with Kennedy no longer with us. It still ends up with Kennedy, who was tortured and eventually killed by this monster. Honestly, 18 years isn't enough, in my opinion. But in the eyes of the law, 18 years is the best they could do. Next, a Florida man is accused of setting fire to a trailer with dead children inside. We're in Pensacola, Florida. A Florida man is facing several charges after allegedly murdering 2 children and setting fire to a trailer with them inside. 27-year-old John Henry Walston Jr. faces a list of charges including first-degree murder, arson, sexual assault, and torturing an animal after the November 7th fire in Pensacola. First responders battled flames at a trailer before going inside to discover the bodies of 2 children. Escambia County Sheriff Chip Simmons said investigators were able to determine that the children's ages 7 and 9 were killed before the fire was set, and one of them had also been sexually assaulted. Deputies said that Walston escaped from the fire and was found in a hospital receiving treatment. Witnesses told WEAR that the children's mother ran into the trailer when she saw the fire to try to save her children. She was taken to a hospital to be treated for her injuries. Tyler Smith, who identified himself as the father of one of the children to WEAR, said the kids had been staying over at the trailer which Walston owned. I don't know what else I can say about this horrible event except please hug your children, Simmons said. Walston is due back in court on November 14th, which is a couple days from now, for a pre-trial detention hearing. How do you kill 2 children, then you set the trailer on fire to cover your tracks? Yeah, there's my answer. He wanted to cover his tracks. He's got to be punished for that. Got to be. Next up, back to the Justice Serve file. Matthew Powell declares at his murder sentencing that he's the only victim here. I may end up sparing you guys the video for this one if there is one. Yeah. Actually, no. I can actually play this one for you. Let's go to the courtroom.
All right, folks, we have breaking news coming out of Wisconsin in the bad boyfriend murder trial of Matthew Paul.
That's right. The verdict is in. We want to get you back inside that courtroom. An hour plus they deliberated. Let's see what they decided.
All right, have a seat, everybody. All 12 jurors have returned. It's my understanding that the jury has reached a verdict. Who's our presiding juror? Is that correct, ma'am? Yes. All right, if you could hand the materials to Mike, please. Okay, what I'm going to do is read the verdict forms at this time. The verdicts read as follows. We, the jury, find the defendant, Matthew E. Paul, guilty of first-degree intentional homicide as charged in count 1 of the information. The second verdict reads, we, the jury, find the defendant, Matthew E. Paul, guilty of hiding a corpse as charged in count 2 of the information. And each is dated today's date, the 4th of November, 2025, and signed by Kathy Meyer, the presiding juror, the foreperson. Ladies and gentlemen, what I'm going to do now is poll each one of you. And what that means is...
All right, so you heard it there. Guilty on all charges. He's only facing those 2 charges, that first-degree murder and the charge of hiding a corpse. Let's bring back in former LA County Deputy Public Defender Philip Dubé to discuss. Philip, your reaction to the verdict?
Well, I'll be honest with you. I'm a little surprised because at most I think what they presented was motive, means, and opportunity. But if you remember, Michael and Ashley, the ME, the medical cause or the manner of death. They found absolutely no human DNA in his home, on his possessions, in his car or truck. And she had a history of suicide ideations and self-epileptic. She had a drug problem. I would not be a bit surprised if this is overturned on appeal for insufficiency of evidence, because as we all know, motive, means, and opportunity does not prove the elements of murder with malice aforethought. So I am a bit surprised.
Interesting. Wow. I'm not surprised. I don't think either of us are, because I felt like there was no other reasonable conclusion based on the evidence.
All right, there you have it. Matthew Powell. That's where he was found guilty of first-degree intentional homicide. He was convicted of murdering his longtime girlfriend and dumping her body in the woods, and he maintained his innocence at his sentencing, telling the judge, "I am the only victim here." Earlier this month, a jury found Matthew Paul, as you just saw, guilty on charges of first-degree intentional homicide and hiding a corpse in the death of Stephanie Pavlins. Pavlins was last seen on August 23rd, 2022, leaving her apartment that the couple shared. Her body was found badly decomposed in the woods 17 days later by a group of construction workers who were posting no trespassing signs in the area. During his trial, prosecutors painted Powell as a controlling and abusive boyfriend who killed Pavlins during a domestic dispute. The couple had been in an on-off relationship, and witnesses testified about previous incidents of violence and controlling behavior. At Tuesday's sentencing, prosecutors emphasized Powell's history of violence and revealed that he had been the primary person of interest in a 1993 murder in Milwaukee. It just shows the violence that the defendant has had for his entire life, Prosecutor Christy Gordon said. Mr. Powell is a violent and abusive man. He is the epitome of domestic violence. When he was offered a chance to address the court, Paul wasted no time firing back at the prosecutors, saying, "I want to correct some of the puke coming out of Gordon's mouth," as he denied any involvement in the 1993 murder. Powell railed against what he called a sham trial called Making a Murderer here in Waukesha and declared himself the victim. "I am the one being murdered by the new Gestapo," Powell said. Paul's attorney, Peter Wolf, questioned his own abilities as he recalled the prosecution's rebuttal closing statement, in which Gordon suggested that Paul murdered Pavlins with the strap of her purse. "I may have made a mistake by never testing that purse," Wolf said. "Never in my wildest dreams did I think they would argue that Miss Pavlins was strangled with the chain of that purse." As he handed down the mandatory life sentence, Judge Ralph Ramirez noted that the jury took less than 1 hour to convict Powell. "In my 40-plus years of legal experience, to my recollection, this is the fastest verdict that I can recall." Ramirez sentenced Powell to a term of life in prison without the chance of release, with an additional 12 and a half years to be served consecutively. "Mr. Paul, I'm not a psychiatrist or a psychologist, but the things I see about you, you're the center of the universe. The universe revolves around you," Ramirez said. "Everyone is wrong, and you're the only one that's right. Sir, what you have exhibited to me demonstrates to me what I consider, and again, I'm not a shrink, this is what I consider to be narcissistic behavior." Restitution was set at $8,309, which Powell said he felt he should not have to pay. Well, that's what happens when you think you're the smartest person in the room, only to find out you're really not. Oh, and on top of it, when you go out bellowing that you're the smartest person in the room, you definitely declared yourself you're not. Life in prison without the possibility of release, plus another 12 and a half years. Yeah, this is the one case on this docket that I can actually say justice served. Let's see what we got next. An Arizona man is on trial in the cold case murder of Allison Feldman. This is one I haven't heard about or covered. Okay. All right, I'll spare you the video for this one. An Arizona man, by the way, this is out of Phoenix. An Arizona man is standing trial for the cold case murder of Allison Feldman. Ian Mitchum is charged with first-degree murder and burglary in the 2015 death of Feldman. Prosecutors accused Mitchum of sexually assaulting, strangling, and bludgeoning the 31-year-old attorney in her Scottsdale home. The case went cold for years until familial DNA testing linked the defendant to the crime through his brother, a convicted child molester. Police later matched Mitchum's DNA to evidence from the scene using a sample collected after the 2015 DUI arrest. Defense attorneys are pointing to another man as a possible killer, according to Scripps News Phoenix, claiming he made incriminating statements and lived nearby. Prosecutors, however, say there's no physical evidence tying that man to the murder. Feldman was found dead on February 18, 2015, after failing to show up for work. The case was delayed for years over legal battles about admissibility of DNA evidence, ultimately upheld by the Arizona Supreme Court in December 2024. Opening statements were scheduled for today, and the trial is expected to last up to 7 months. This is one of those cases, to me, that it's high time that this one is wrapped up. It's high time this one is solved. This one, it's time for justice to be served in that case. Next, bond denied. Judge denies bond for Victoria Tippett, citing her to be a danger to the community. Here's another judge doing the right thing, as far as I'm concerned. Oh yes, I can go long. All right. All right. We're in Anderson, South Carolina for this one. A woman accused of helping her roommates dispose of a dead body was denied bond again and will remain behind bars as she awaits trial. Victoria Tippett is charged with accessory after the fact and obstruction of justice in the death of Jessica Barnes, whose remains were found in September 2024. Prosecutors say Jessica was strangled to death by her husband, Brandon Barnes, who lived with his wife, Tippett, and a third woman, Kendall Mims. Mims and Tippett faced the same charges. At a hearing in April, a judge granted Mims a $75,000 bond after her attorney described her as a victim of psychological torture at Brandon's hands. At Wednesday's bond hearing, Tippett's attorney, Hunter Bluen, said that his client was also a victim of abuse. It's apparent that Mr. Barnes was both physically as well as psychologically and potentially sexually abusive towards all these women. It's our position that Ms. Tippett, once she got involved with Mr. Barnes and moved into that house, she had nowhere to go. Bluen told the court that Tippett had gotten involved with Brandon a month and a half before the murder and moved into the house 3 weeks before Jessica disappeared. After Jessica was killed, investigators say Tippett and Mims helped Brandon dispose of her body by removing her from the home in a large plastic tote that she was seen buying with Brandon at a Walmart. A portion of Jessica's remains were found in a bucket buried on a property where the four lived. Her teeth and part of her jawbone were found at a site off a hiking trail. Jessica's mother, Cecilia Varvara, had a statement read at the hearing and urged the judge to keep Tippett behind bars. Every bond hearing is not just a legal proceeding, Varvara wrote. It slices through our grief and breaks open the pain we desperately want to seal. There are moments in the night when I wonder if our family will ever be able to mourn Jessica and begin to heal. Judge R. Lawton McIntosh ultimately sided with the prosecutors, who argued that Tippett was a flight risk and a continued danger to the community, as he denied bond. Brandon also remains behind bars without bond pending trial. And to that, I say, well done, Your Honor. When you believe a defendant is a danger to a community, the best place for that defendant to be is behind bars until he or she goes to trial. And especially given the severity of the charges, yeah, that's exactly where Victoria Tippett needs to be at this moment. Got an update on Antonio Brown. Antonio Brown is getting a $25,000 bail on attempted murder charge after pleading not guilty to said charge. All right. Again, I will spare you the video, but I'll dig right into former NFL wide receiver Antonio Brown will be released on $25,000 bail and must wear a GPS ankle monitor on an attempted murder charge in Florida, according to an order by the judge on Wednesday. The 37-year-old has pleaded not guilty to the second-degree attempted murder charge, which carries a potential 15-year prison sentence and a fine of up to $10,000 if he's convicted. His lawyer, Mark Eiglash, said Brown would return to his home in Broward County, Florida, while the case proceeds. He no longer has a passport. He'll be living at his home. I look forward to working with him zealously on his case, Eiglash told Circuit Court Judge Mindy Glazer at a bond hearing. Brown appeared at the hearing via video wearing a red jail shirt and spoke only to answer questions from the judge. Prosecutors had sought pretrial detention, contending Brown is a high-paid former professional athlete with the resources to flee. According to an arrest warrant, Brown is accused of grabbing a handgun from a security staffer after a celebrity boxing match in Miami on May 16th and firing 2 shots at a man he had gotten into a fistfight with earlier. The victim, Zol Kwarnin Kwame Nantambu, again, if I mispronounce that name, count it to my head and not my heart. According to the victim, he told investigators that one of the bullets grazed his neck. Brown's attorney said Wednesday that the affidavit is mistaken and that Brown actually used his personal firearm and that the shots were not aimed at anyone. It was my client's own gun, Eiglash said. Based on his social media posts, Brown had been living in Dubai for several months. In a social media post after the altercation, Brown said he was defending himself because he was jumped by multiple individuals who tried to steal my jewelry and cause physical harm to me. Eiglash said Brown has unspecified business interests in Dubai and always intended to turn himself in on the attempted murder charge. He didn't flee to Dubai, the lawyer said. He always had a desire and intention to answer this case. Brown, who spent 12 years in the NFL, was an all-pro wide receiver who last played in 2021 for the Tampa Bay Buccaneers, but spent most of his career with the Pittsburgh Steelers. For his career, Brown had 928 receptions for more than 12,000 yards and accounted for 88 total touchdowns, counting punt returns and 1 pass. We'll just have to wait and see what becomes of Antonio Brown's case on the intended murder charge. Next up, a case I am following extremely closely. While 9-year-old Melanie Buzzard is missing, her mother, Ashley, was arrested on an unrelated charge. Now, the judge is ordering her to be released from custody. Okay, I'll spare that one as well. Okay, the mother of a missing 9-year-old Vandenberg Village girl who was arrested last week on a felony charge unrelated to her daughter's disappearance will be released from custody, the judge ruled Wednesday. 40-year-old Ashley Buzzard has been behind bars at Santa Barbara County Northern Branch Jail in Santa Maria since her arrest Friday. A criminal complaint filed by the Santa Barbara County District Attorney's Office charged Buzzard with false imprisonment in connection with a November 6th incident involving a man identified as Tyler S. Brewer. Brewer, a local paralegal, told Scripps News San Luis Obispo he knew Buzzard years ago and contacted her to assist with the missing person investigation involving Buzzard's daughter, Melody. Brewer says on November 6th he was visiting Buzzard at her Mars Avenue home in Vandenberg Village when she wouldn't let him leave. Buzzard was arrested the following day. The arrest came nearly a month after Melody was last seen on surveillance near the Colorado-Utah border while on a 3-day road trip with her mother that spanned as far as Nebraska, authorities said. In court on Wednesday, it was stated that 3 search warrants have been served at Buzzard's home so far in connection with her daughter's disappearance, and that she has no criminal history. Buzzard's attorney argued that his client was not a flight risk and that the complaint was nonviolent in nature. The prosecutor, however, disagreed, stating that a box cutter was involved in the crime and that authorities had discovered she wore wigs and switched license plates on the road trip she took with her daughter. Buzzard pleaded not guilty to the false imprisonment charge, and the judge ruled that she could be released with supervision and must stay away from Brewer. She was also prohibited from possessing weapons. Until now, Buzzard had been held at the jail on $100,000 bail. A few family members from Melody's father's side attended the hearing. Melody's grandmother, Lily Dennis, was extremely upset by the ruling and also said she doesn't recognize Buzzard at all. Buzzard stood alongside her attorney during the hearing, her hands crossed and wearing a sweater. The only word she spoke appeared to be "good morning" in a very faint and delayed response to the judge addressing her. Melody was reported missing on October 14th when a school administrator reported her prolonged absence. Authorities said it does not appear she ever returned home from the road trip she took with her mother. Buzzard's next court appearance is set for November 19th in Lubbock. The investigation into Melody's disappearance remains active, with the FBI assisting the Santa Barbara County Sheriff's Office. So, she'll get out of jail on this unrelated charge, yet she remains silent when it comes to the whereabouts of her daughter. I honestly believe deep down in my heart that she has something to do with her daughter's disappearance, and it has a lot to do with that 3-day road trip. I want to be wrong about this, though. I really want to be wrong, but I got a feeling. I just got this disturbing feeling that Melody has been trafficked. And again, guys, I hope I am wrong. Next up, a father admits to killing his daughter and the family cat by saying, "I pulled the trigger." We're in Canyon County, Idaho. A father accused of killing his daughter and threatening his son emotionally admitted his crimes in a Canyon County courtroom on Wednesday. Delbert Cornish formally pleaded guilty to first-degree murder for the October 18, 2025 shooting death of his daughter, Hope Onyx Cornish. In a tearful courtroom confession, Cornish told the judge, "I pulled the trigger. I shot my daughter." When asked by the judge if he understood what he was doing when he fired the 9mm handgun, Cornish responded, yes. Prosecutors say Cornish also shot and killed Onyx's pet cat during the same incident and later threatened his teenage son, Lucian, who managed to wrestle the gun away and flee the home to call for help. Cornish also pleaded guilty to assault with intent to kill and animal cruelty. First-degree murder in Idaho carries a mandatory sentence of life in prison without the possibility of parole. The judge has scheduled sentencing for January 28, 2026, setting aside 4 hours for victim impact statements and testimony. Onyx's mother, Crystal Thompson, described hearing Cornish admit to the crime as devastating. That was hard. That answer was really, I don't know. It's like a truck hit me. Just to hear him say it, she said. It's made it all the more real, and I'm struggling right now with that. Despite the trauma, Thompson says Lucian has turned to music to process his grief and is planning to give a victim impact statement at his father's sentencing. He wrote a song, actually, and he's writing an album. It's so emotionally raw, she said. Again, Lucian plans to deliver an impact statement at his father's sentencing. What could she have done? What could she have done for her father to kill her and the cat? Maybe it'll all come out on the 28th of January. So that's a wait and see thing. And finally, last case on the docket. A judge declines to dismiss sex trafficking case against real estate brothers. This is one I've been following for quite a bit also. We're in my old stomping ground of New York City. A 2-decade pattern of alleged sex trafficking by 2 luxury real estate brokers and their brother wasn't just men behaving badly. That's according to a federal judge, as she left their indictment largely intact and rejected defense efforts to minimize the gravity of crimes involving dozens of women. In an October 17th opinion unsealed Wednesday, Judge Valerie E. Caproni expressed skepticism about some of the arguments defense lawyers offered as they tried to get the charges thrown out. As much as defendants want to characterize the charged conduct as just men behaving badly, that is not what the indictment charged, she wrote. She said the charges allege that 3 grown men conspired to entice women and girls to travel domestically and sometimes internationally to luxury hotels where they were drugged and sometimes physically restrained before they were raped or sexually assaulted. Caproni did dismiss one attempted sex trafficking count, finding that the 5-year statute of limitations had expired. The 3 brothers, Orrin, Tal, and Alan Alexander, remained held without bail after pleading not guilty to the charges in Manhattan federal court. Orrin Alexander and Tal Alexander sold high-end properties in New York City, Miami, and Los Angeles before the charges were filed, alleging that they used their wealth and influence to attack women from 2002 to 2021. A defense lawyer said last week that the defense plans to show a jury that witnesses are lying at a trial scheduled for early January. The judge has said she might postpone the trial until May. Caproni rejected defense assertions that the alleged crimes by the brothers were more like date rape allegations more normally prosecuted in state courts. That badly misrepresents the nature of the charges, the judge wrote. She said the allegations make clear the alleged crimes were not sexual assaults that serendipitously occurred when a group of people in their 20s or 30s went on vacation or during dates at parties. At a hearing last week, defense attorney Mark Agnifilo said the jury will hear evidence at trial of group sex, threesomes, and promiscuity. This case is about sex and sexuality, he said. In court papers, defense lawyers wrote that among the accused they expect to testify at trial, they located evidence that undermines nearly every aspect of the alleged victims' narratives. They say they believe that many witnesses are going to testify untruthfully on direct examination, whether it be because of their own current situation, their motive to lie for monetary gain, or their situation at the time. These witnesses do not want to admit to the world that they consensually engaged in sexual activity with any of the Alexander brothers, the lawyers said. But Caproni wrote that she fails to understand how certain categories of information cited by the defense are likely to disprove the charges, such as proof that victims continue to contact or interact with the brothers or that they initiated contact with them. She noted that a handful of messages cited by the defense regarding one accuser are contradicted by other messages, including one in which she expressed how she did not know how someone could so dislike her that they would harm her. So once again, another case and another judge not dismissing the charges. That's going straight to trial, and we'll hope to find out what becomes of that case. And with that, ladies and gentlemen, I'm about ready to wrap this up. But before I do, I've got one last thing to say, and this is my closing argument. All right, let's get this up ahead. And all right, at the top, I told you that I was coming in the spirit of Joe Friday, bringing just the facts. We don't gather facts to feel safe. We gather them to be faithful. To see clearly is to love deeply. And when we name what's real, we make room for what's possible. So let's not flinch from the truth, even when it's heavy. Let's carry it like a lantern, not a weight. Because the facts don't just inform us, they form us. They form us into people who can speak with conviction, act with compassion, and walk with hope. That's the power of knowing. That's the mission. And that's my closing argument for this midweek bite. I want to thank you all for joining me here. And I hope and pray we can do this again next time. Be sure to follow me all over social media. And let's get justice for all the victims involved, and let's get the missing home. All right? Let's do this again. Let's do this again come next week. Until then, I'm Ernest Bethea, the Last Outlaw, and this is Bethea'S Byte. And it's reloaded.
Thank you all for joining me here at the Drama-Free True Crime Destination. Be sure to follow Bethea'S Byte Reloaded all over social media and get your coverage of true crime news with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.